welcome to Crime in Court. My name is Heather, and this is an update in the Idaho 4 case. So, this is obviously the case of Idaho versus Brian Kohberger in the homicides of the 4 college students Madison Mogan, Kaylee Gonzalez, Eric Chapin, and Xana Kernodle. So, this week, there was a hearing for scheduling. They wanted to set dates for scheduling because not just when you have a trial date, you have to also schedule a whole bunch of things that lead up into that time. So the judge really wanted to get these things moving in order so that they were on the schedule and not overlooked. So that's what this hearing is about. This was Thursday, June 27th, that it took place in the afternoon. It's very short. We're gonna watch a little bit of it and make sure I got captions on. Here we go. So again, this is a scheduling hearing that took place. It's only 13 minutes long in total, so it's very short. But at the end of this, since the Karen Reed case has been going on, and I've been covering that really intensely, extensively, because of that, I haven't had a chance to actually review the the May 30th hearing, which they had the defense called experts to the stand, law enforcement to the stand, discussing different issues and problems with the discovery and the DNA and all sorts of things. So we're going to watch that at the end of this. So just be aware if haven't had a chance to comment on it. So that's coming up too. All right, so here is yesterday's hearing up first. Let me unmute you.
CR 2922-2805. Present in the courtroom is Mr.
And that is Judge speaking. It is his Zoom feed, I guess, and his YouTube channel that airs this. They don't have like a law and crime doing it or a court TV because it's coming directly from Judge's feed. So this is the audio, this is the camera. Unfortunately, this is the angle we have, and that's pretty much it. It's very hard to see people's faces, especially in the background here, but you can see Bill and I forget the other lady's name. And then you got Ann Taylor, who is representing Brian Kohberger, sitting right there. And then here, obviously, is Judge. So let's get started. Oh, and please hit that like button. Thank you so much. I know it's annoying for me to say, it's annoying to remind you, but it's a good reminder because it helps push out this video to more people and it helps YouTube know what videos you like.
Kohberger, represented by Ms. Taylor, and Ms. Massa and Mr. Logston are participating over Zoom remotely. The state is represented by Mr. Thompson and Ms. Jennings, Latah County Prosecutor's Office, and Mr. Nye and Ms. Beatty are participating over Zoom remotely. So we're here for a scheduling order, and I think we're about 13 months from the arraignment, and I think at this point, this is my opinion, that we're getting to a point of diminishing returns, and I sent to counsel last Friday on a proposed scheduling order for a lot of things, deadlines, including setting the trial. And so I also have set this hearing so that we can discuss this and see kind of where everybody is. So let me start with the state. Thanks.
Thank you, Your Honor. We reviewed the court's proposed scheduling order with the attorney team, and we are agreeable to it. It makes sense that we do the trial in the summertime when high school is out across the street and when the university is out in the conflicting activities. And the schedule that Your Honor proposes is acceptable to the state. I would note just a minor detail that June 19th is also a legal holiday. The court specified July 4th that as a legal holiday, we wouldn't be able to hold trial, but June 19th as well. Other than that, we have no objection to the court's proposal.
All right, thank you. I mean, as I went through all of this, I mean, there's going to be a lot of motions, a lot of hearings, a lot of work. There already has been a significant amount of work, as we all know. And when I tried to balance this out, I do think it's pretty fair, balanced, and I hope realistic. So, Ms. Taylor.
Thank you, Judge. Your Honor, first, I know the court has listed this as taking place in Latah County. We haven't been heard on our change of venue yet. That's
Totally
Tacoma.
understand that.
So I don't want anybody thinking I'm agreeing to Latah County is all. The June of 2025, that's the time frame that we have been working towards. I am hopeful that we can come in there. We're working towards that date. I think it's reasonable to set that date. As the court's aware, mitigation is something that takes a significant amount of time. We've had that underway since the day we took this case. We continue to work that very hard. I spoke with our mitigation expert last night about this date. And there's a lot of work yet to be done, but we're still working towards that. So I think it's reasonable to set that. I just want the court to know that that's not finished at this point. That's very much ongoing, and new things are coming out that we need to follow up. But with that said, I think it's reasonable to go ahead and pick the June of 2025 as a trial date at this time.
But by the way, I think you understand that, all counsel understand that, but this is a 3-month trial. So I was calculating 2 weeks to set the
A 3-month trial. Did you hear that? 3 months.
jury, then 8 weeks of trial, and then 2 weeks for mitigation and sentencing. And I mean, that's a guess, but
So technically, for the trial, the jury trial, it's only 8 weeks, and he's adding on all this other stuff for scheduling. So 3 months altogether of craziness, I'm sure, for the attorneys and for the judge when you're trying to arrange all that in your courtroom. But yeah, so 8 weeks they're saying now for the actual jury trial.
I think it's enough time for all of those things to take care of. And obviously, the last 2 weeks would only be if Mr. Poker was convicted. Okay, go ahead.
Thank
That
you,
would
Your Honor.
that would be the sentencing phase. If he is convicted, then he would have to go on to the sentencing phase because this is a DP case. He most likely has to have, a whole sentencing here. So he'll have his trial, first of all, and that'll decide whether he's guilty or not. And if they find him guilty, then they'll have more evidence to put on and try to educate the jury on how they should sentence him and what the difference between DP and people that are in prison for life. And they'll go through experts like that, and then the jury will have to decide his fate yet again and decide whether he gets the DP or not. A lot of power to have in your civic duty to decide whether someone gets the DP or not. That's rough. I don't think I would want to be put in that situation.
I do want to bring up a couple of issues I have with some of the deadlines. I looked this over. Our team has talked about it. I've gone over this with Mr. Koberger. I do have a couple of concerns about the deadlines, and I'll just bring those up to the court for the court's consideration. As far as motions challenging the death penalty, and that's in right under motion practice letter A that the court has on its draft, we can have a lot of those filed by September 5th. I would note for the court that that's ahead of the state's final discovery date, and that's ahead of the state's deadline to produce its aggravation case that it will use. We can meet the September 5th deadline, but we're going to ask the court to give us a little leeway when there's something new that comes our way. If there's an amendment to a motion or a new motion that becomes relevant based on something new, we'd like a 2-week window after receiving something new to file that. But the bulk of it we can get in by the deadline that the court has asked here, and that's just not a problem.
Sure, I understand that. I looked at that. I wanted to have that early because, it's a bigger question.
Yeah.
And I was aware of the Ross case. I think you had 16 motions in that case. So I wanted to sort of address those issues early.
Your Honor, we can definitely do that. We can address a lot of things early. We just don't want to be precluded from bringing an amended motion or a new motion if something new is filed that would have been relevant to something we've already filed.
I'm not going to prevent you from doing that.
Perfect. Thank you.
And by the way, a lot of these deadlines, you can certainly do them earlier if you'd like to. I would encourage everybody to do that. Thank you.
Your Honor, then moving on, the motions in limine under letter C, the court has suggested February 13th as the date for that. I think in large part we can do some by then, but the exhibits that we'll exchange and witness lists that we'll exchange aren't due until after that. And again, I think there might be additional motions that would be relevant after those things have been exchanged. So If the court wanted to move the whole deadline, so we had all of those motions in limine at once, I think that would be reasonable. But if the court wants to keep this deadline, as long as we have the ability to bring more motions in limine based on new filings, we'll be okay with that as well.
Sure. And I was also thinking about, you know, I guess experts, for example, I mean, they may have longer hearings that, you know, we're going to have to work through all these things. I mean, this is just a structure.
Thank you. The court had listed March 14th as a trial brief date, and that is ahead of some of the other deadlines, recognizing that the trial is the innocence phase and the sentencing phase, if it happens, is the mitigation and aggravation. I would just say this is a fine deadline, but we won't be touching anything to do with our mitigation by then, if that's what the court anticipated.
Yes.
Okay, perfect.
I think we, well, yeah, we had March 3rd for mitigation. I figured by then he would pretty much have that in hand.
We should, we hope to. That brings me to the last point I wanted to talk about. The court has proposed setting a mutual exchange of aggravation and mitigation materials, and I'd ask the court to reconsider that. We will aim for our March 3rd deadline. That's our plan right now. If something changes that, then we'll come back and let the court know and talk to counsel. But would ask that the state's aggravation package be provided to us earlier than the same day as our mitigation. Should we get to that point, the state has the burden of establishing statutory aggravators. There are some things I think I might be able to guess about how the state's going to try to present information, but I don't think I should have to guess. I think I should have that information well ahead of providing the mitigation that will be presented in response to any aggravating information that's presented by the state. So I'd ask the court to set the date for the state to produce its information much earlier than ours. The state filed its notice a year ago yesterday, and I have a lot of questions about what the state would intend to use to try to establish many of the statutory aggravators they've listed. I know I've heard the court talk about super due process in a capital case, and I think it's appropriate for us to be on notice and be provided discovery, to be provided a full range of what the state intends to use to establish those if we ever get to that point. And I think we need those ahead of our deadline for mitigation. So I'd ask the court to move that deadline up quite a bit earlier. And that's it.
Thank you very much. Mr. Thompson, do you have any issues about having the aggravation in advance for a period of time?
No, sir. As long as we will have the option, ability to supplement that once we see whatever the defense plans to offer in the way of mitigation.
Well, I'm appreciating that, you know, with these deadlines, that we're going to have supplement all the way along. I just don't want to be scrambling around a month before the trial. We're all going to be very, very busy. And the more we can resolve certain motions, you know, supplements, whatever we need to do, I'm trying to do this sooner than later.
Yes, sir. And that's our preference as well.
And Ms. Taylor as well.
Yes, Your Honor.
But just to make sure, though, I mean, you have to do your job, and the state has to do its job, and I have to do my job. But I think this is a great step, okay, to set these deadlines and hearings so that we can move through this. It's going to take a while, but anything else we need to address today, Mr. Thompson?
I don't believe so. Thank you.
Ms. Taylor?
No, Your Honor. Thank you.
Okay, well, it's very short, and I'm grateful that everybody's working together. Thank you.
All right, so that was this week's hearing. So I'm gonna switch us over here. I want to show you guys or read to you rather, the actual the scheduling order that came out after this hearing. Was it after this hearing? Hold on, I don't want to be telling you the wrong thing. Maybe this was his proposed hearing. Nope, dated June 27th. All right, so this must be the final order. All right. Scheduling order. Trial setting. A jury trial shall commence at 8:30 a.m. on June 2nd, 2025 in courtroom number 3 of the Latah County Courthouse and will run until August 29th, 2025 on an 8:30 a.m. to a 3:30 p.m. schedule. So what was I going to say? So the Latah County, I didn't mean for the sensitive trigger warning to be here. We don't need that, sorry. So this portion here, the Latah Courthouse, that's what Anne was talking about because she has the motion to change venue. So they're trying to get it, a different jury pool into this trial so that people out of the area um, won't be so prejudiced against him. And that's what I think. Like a lot of people who are locally already have thoughts about the case. So that's part of the problem. But it's also a national case. So I don't know if changing a venue is going to really work, but we'll see what comes of that. All right, so these dates are inclusive of jury selection as well as any sentencing phase that may be necessary. The defense's motion to change venue is currently set to be heard on August 29th, 2024. If that motion is granted, the court anticipates that the trial dates will not change, although the location of the trial would. All right. B. A final pretrial conference will be held on April 3rd, 2025 at 10 a.m. And here are the motions. A. Any motions challenging the DP shall be filed on or before September 5th, 2024. Any responses shall be filed on or before October 10th. Any replies are due by October 24th, and a hearing on the motion shall be held on November 7th at 10 a.m. So if you guys are really avid watchers and you want to mark these things on your calendar, I would do it now so you remember that these dates are coming up for these motions hearings. All right, so motions to suppress evidence and any other 12B motions shall be filed no later than November 14th. Responses shall be filed by December 19th. Any replies shall be filed by January 10th. A hearing on the motion shall be held on February 6, 2025 at 10 a.m. and may continue into February 7th if needed. C. Motions in limine, including any 404B notices, which is like what they want to exclude. They make motions on certain parts of evidence that they want to either exclude or include in the trial. And so if something's in like 404B, then it's like protected. The other lawyer's not supposed to question any of the witnesses on that, whatever topic or whatever item it is. All right, so motions in limine, including any 404 notices, shall be filed by February 13th, 2025. Any responses are due by March 13th. Any reply shall be filed by March 20th. A hearing on the motion shall be held on March 27th, 2025 at 10 a.m. and may continue into March 28th if needed. Discovery completion. A. The state's discovery deadline is September 6th, 2024. B. The defense's discovery deadline is January 9th, 2025. And they get more time because they have to go through the state's discovery and find experts, interview them, do depositions, do all that work up until January 9th until they have their experts and the people they want to call and they know their witnesses, and then they can start turning their discovery and witness lists over after that. Disclosure of trial experts. A list of experts, along with a copy of the expert's report consistent with the ICR 16B7 and a copy of the expert's curriculum vitae, which is just a fancy word for resume, the state intends to call at trial shall be disclosed to the defense and the court by December 4th. A list of experts, along with all that same stuff, must be provided by the defense by January 9th, 2025. So they get a little extra time, but not a whole lot. Any rebuttal experts for either the state or the defense must be disclosed by January 30th. Trial materials. A. Proposed jury questionnaires shall be provided to the court by February 7th, 2025. Responses must be filed by March 7th. Pursuant to all these codes, a closed, sealed hearing on the jury questionnaires will be heard on April 2nd, 2025 at 10 a.m. So they'll discuss all the things that they want their jury to, that they want to ask their potential jurors in voir dire process. All right, B, proposed jury instruction shall be filed with the court by March 14th, 2025. Jury instructions will be discussed at the final pretrial conference. C, lay trial witness lists shall be filed. So not not your experts, but your lay people, like you and me, unless you're an expert in something. The lay trial witness list must be filed by March 14th, 2025, and D, exhibit lists with attached copies of exhibits shall be filed by March 14th, 2025. Each party shall prepare a list of exhibits that it expects to offer, excluding impeachment documents, to the court and to opposing counsel. That's interesting. You can exclude documents that you want to use to impeach a witness. That's interesting. Exhibits should be listed in the order that the party anticipates they will be offered. Each party shall affix labels to their exhibits before trial. The state's exhibits should be marked with red labels in numerical sequence with an S before the number So, for example, S1, meaning state exhibit 1, defendant's exhibit shall be marked with blue labels in numerical sequence with a D for the defense. So D1 example. The case number should also be placed on each of the exhibit labels. Exhibits should be lodged and served as required by this pretrial order. Exhibit labels can be obtained from a deputy court clerk. So to make sure you use the right label, get it from the clerk. Counsel shall provide a copy of each exhibit and an exhibit list to opposing counsel and the court. Copies should be made after the labels are marked and attached to the original exhibit. To expedite the trial, each exhibit to be offered should be viewed by opposing counsel prior to trial and a determination made as to whether an objection will be lodged against the exhibit. An exhibit to which there is no objection will be admitted prior to trial. E. Each party shall provide the court with a trial brief which shall be filed on or before March 14th, 2025. Sentencing disclosures. A. Any witnesses, lay or expert reports, and a list of exhibits with copies attached the state intends to present is support of aggravation shall be provided to the defense and the court by January 9th. Defendant's mitigation disclosures, including all witness lists, lay and expert reports, and a list of exhibits with copies attached shall be provided to the state and the court by March 3rd. Any witnesses, lay or expert, and exhibits the state intends to present in rebuttal shall be provided to the defense and the court by March 31st. How do you know what rebuttal witnesses you might have? I don't know. All right, filings after deadline. I mean, how do you know them that early? If you're March, April, June, I mean, you're 3 months away. What if something comes up in the middle of the trial and you need a witness to contest something or rebut something? I hope they have a way to do that. Anyways, filings after filings after deadline. The court reserves the right to hear any motions filed after a deadline has passed if good cause is shown, including but not limited to motions that arise after a disclosure made by the opposing party. So motions that arise after trial starts per se, and you might need a new expert to rebut something. I don't know. So that is Judge's order for scheduling for the Idaho versus Brian Koberger case. And if you're already caught up with the May 3rd video or hearing, I should say, we're going to get into that. This is a long one, which is another reason why I just never had the time to go through it. So we're going to go through it now. It's a 3-hour video. However, I do have it sped up, so hopefully it's not so long. But it's going to be Ann Taylor calling certain individuals to the stand to talk about discovery issues and DNA and things like that, things of that nature. So let's dive in. This is a long one. And again, reminder, if you haven't hit the like button, please do so. It really helps the algorithms, and I really appreciate it.
We need to sort that out. That's going to be in the morning, and that is open, obviously. And afternoon, starting at 1:30, we're going to address genetic genealogy. I think that's the plan. Okay, so starting with you, Ms. Taylor.
Thank you, Your Honor. After last week, we had one witness testify, and I have two additional witnesses this morning, and then there will be witnesses this afternoon in closed session as well.
Okay.
And I'd be prepared to call my next witness.
Okay, go ahead.
Called Brett Payne.
Okay. Thanks, sir. Please come forward. Raise your right hand.
You solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, thanks, sir. Please have a seat. And then when you're seated, please state your name and spell your last.
Name is Brett Payne, last spell Payne.
All right, thanks, sir. Ms. Taylor.
Thank you. Good morning.
Morning.
Will you tell us your occupation?
I am currently
Helps if I had my mic. You might recognize Brett Payne. He is one of the lead investigators in this case. He, I don't recognize him without the hair, but let's look him up. Brett Payne, Idaho. So you might recognize him. Not, I'm struggling here with my. Come on. Okay. Huh. I don't know what I just clicked on, but I just clicked on his image and it says revealed lead investigator in Idaho murders is a U.S. Army vet with just 2 years of police experience as desperate FBI adds agents and families grow even more impatient. So when was this? The Daily Mail. I don't know how. This is today. The lead investigator in this excruciatingly slow probe of 4 Idaho students is a 32-year-old U.S. Army vet who only joined law enforcement 2 years ago. I did not know this. So we're learning as we go. All right, it has been over 5 weeks since Kaylee Gonsalves, Maddie Mogan, over 5 weeks. This must be an old article that just resurfaced. Ah, here we go. It was published in 2022. It was just updated though. Or, oh, that's just the, okay. I was confused. That's the heading. So this is an old article, but still, um, it's good to know that he only had two years of police experience, and he's the lead investigator of the highest profile homicide case in Idaho ever, probably ever. Maybe Daybell and Lori Vallow might be higher. I'm not sure, but I don't know. This one's pretty crazy. So this was written a while ago. Obviously, I'm not going to read it all, but hopefully you can see his head there. Why am I? Okay, hold on one second. All right, here we go. Now you can see Brett Payne. Here's an older picture of him and his brother. I think this one's him, but I can't even tell. They look the same. Payne, shown with his brother Kyle when they both served in Afghanistan, was part of the 82nd Airborne Division. And now we know he only had 2 years of law force experience when he did the investigation. So that's Brett Payne. That's who's on the stand right now. And he's going to talk, or Anne's going to question him on some of the investigation techniques.
employed by the Moscow Police Department as the detective corporal.
What experience do you have prior to Moscow Police Department?
I was served in the military for 6 years. 3 of those were as a commissioned officer in the military police corps.
How long have you been with Moscow Police Department?
6 years.
We're here to talk about the case of State of Idaho versus Brian Koberger. Have you worked on that case?
Yes, ma'am.
What is your role in that case?
I was assigned as the case agent for Moscow PD for that investigation.
Does case agent mean you're the person in charge?
Yes, ma'am.
If I called you the lead detective, would that be a term that's the same thing as person in charge and
Yes,
case
ma'am.
agent?
Yep.
Okay, thank you. What were your general responsibilities as the lead detective in the case?
So when I became case agent, I was assigned to work the command post that was established at the Moscow Police Department, along with my partners in Iowa State Police and the FBI. We managed the command post and directed the general direction of the whole investigation.
Would that mean you would be a person to write warrants and affidavits in support of warrants?
Yes, ma'am.
Did you conduct or direct interviews?
Yes, ma'am.
And did you search for a suspect?
Yes, ma'am.
Were you the go-to person and the person in charge for evidence that would be brought into Moscow Police Department to support the case?
No, ma'am, I was not.
Who's in charge?
That would have been our evidence custodian.
As the lead detective, were you aware of the evidence that would be under the control of the evidence custodian?
Not entirely. I was made aware of basically the most pertinent evidence that was coming in, but I was not aware of every single piece of evidence that was brought into the police.
Okay.
Hmm.
During the course of, I guess, the investigation from November 13th forward, was there videos that were collected, like a video canvas done of the community?
Yes, ma'am, there was.
Is that something you were involved in?
No, ma'am, I was not involved in the direct collection of those videos.
Who is responsible for the video collection and knowing what videos exist?
So the way that worked was individual investigators who went out in the community and collected those videos, brought them back to the police department and provided them to our digital forensics office. And then they were later booked in through that channel.
So the digital forensics office would be the responsible entity to receive these pieces of video surveillance. Is that right?
Yes, ma'am. I would say it was a dropping off point for those cases. Yes.
And who is that person?
That was a joint effort between Detective Mowry and several people within the FBI.
Which people within the FBI?
I do not remember.
Detective Payne, I'm asking because last week, Detective Mowry told us that he wasn't in charge of these videos. And I need to know what they are. Do you have any idea who the FBI agents are that were also in charge of this?
And we could certainly find that out for you, yes, ma'am. I don't know off the top of my head.
Okay, well, I'm going to.
Isn't that a problem that you don't have a chain of custody for things that you're using in evidence for this case, and you're supposed to be the lead officer in this case, and you don't even know where things are? That's concerning.
Going to need to do that. Let's talk a little bit about what surveillance is out there. These were cameras from different businesses. Is that right?
Yes, ma'am, as well as some private residences.
Let's focus on the businesses for just a minute. Those would be collected at main points in Moscow where you might find a person of interest. Is that right?
Yes, ma'am. We canvassed pretty much the entire city of Moscow looking for places that were willing to or could provide us video.
And was it also important to think about if somebody were to come into or leave Moscow, the kind of video cameras you might find on those areas?
Certainly, yes, ma'am.
And that would be the east-west road between Moscow and Pullman. Is that right?
Yes, ma'am. Referring to SR-270/Pullman Road. They wanted that to refer to.
I know that as the Moscow-Pullman Highway.
Yep.
I think that's the same thing, or Highway 8.
Works for me.
And that goes from Pullman out towards Troy in that area.
Yes, ma'am.
Okay. And also important in that video collection would be the north-south Highway 95, the north end of Moscow and the south part of Moscow. Is that correct?
Yes, ma'am.
Okay. And so you collected business videos or had that done, but who I need to talk to about this would be Detective Mowry or an unnamed FBI agent. Do you
Or
understand that?
the agents who were the officers investigators who collected that specific video would have written reports to the best of my knowledge, stating such that they collected video from X, Y, and Z. That would be the best person to speak to about that particular video.
But if they collected it and gave it to Moscow Police Department or the digital evidence people, isn't it your department that I'd be looking at and say, where is this now?
Yes, ma'am.
Okay. Well, I'm going to talk about some of those specific ones, but you brought up,
Why is it so confusing? If you guys have a process, you should know where things are and who has what and who's done what. But it doesn't appear that they do that. It's like, okay, well, I'm over here in my little silo and I've got people over there collecting evidence, but they don't even tell me what the evidence is. That's interesting.
residential cameras in that canvas as well. Are you talking about things like Ring cameras?
Yes, ma'am. Ring cameras and other sorts of private security systems that people may have had.
Ring cameras have a way of sending out a notice to Ring camera owners to check their data. Is that right?
I believe so.
Was that done in this case?
I do not remember if that was done or not.
Are you familiar with some of the Ring cameras or home surveillance videos in this case?
Yes, ma'am.
In particular, I think your affidavit talked about one on Indian Hills Road. Do you know what I'm talking about?
Yes, ma'am, I do.
How did that camera come to your attention?
I believe Detective Vargas works for MPD. She contacted the residents at that, the person who lived at that residence, and they provided that camera footage to Detective Vargas.
Do you know why she contacted them?
I believe it was part of just the video canvas, best of my knowledge.
Now, I want to talk about some of the specific businesses, and you mentioned that I'd be looking at a police report to tell me if it existed or not. As the case manager or lead detective, are you familiar with the reports from other officers that may have talked about turning in videos?
Some of them, certainly not all of them.
Your Honor, I'm going to ask that he be handed two defendants' exhibits. They are RR and SS.
Yes, thank you.
One of the videos I want to talk about comes from the Red Star Coffee Company. Do you know where that business is located?
Yes, ma'am.
Where is it?
That's on Pullman Road and right next to the steamer station.
So the Pullman Road, that's also known as Moscow Pullman Road, within the city of Moscow?
Correct.
Okay. And if you look at Exhibit RR, and if I can draw your attention to on page 2 to paragraph 9 and page 3, paragraph 9 continues over there. Our surveillance video was collected and given to Moscow Police Department.
It reads that way, yes, ma'am.
Where is it?
I do not know.
Who do I ask?
Sorry,
View of that. Am I correct in based on your review of that, am I correct in believing that the Red Star surveillance video was collected and given to Moscow Police Department?
It reads that way, yes, ma'am.
Where is it?
I do not know.
Who do I ask? Where it is?
That would be through the evidence custodian and MPD. That'd be my best direction for you.
So I need to go to the evidence custodian and ask him to bring all of the videos out so I can watch them all to see if that one exists.
Yes, ma'am.
How many hours of videotape do you think have been collected?
A lot.
Shouldn't the police have turned this over already? Like, why, if it, well, turned it over in regards to discovery for the prosecution, and then therefore the prosecution turns it over to the defense. So it just doesn't, I don't know. It should have already been reviewed, looked at. It should have been admitted into evidence, don't you think? Or handled like it's discovery in the case, because it is. So why wasn't it turned over to the defense or prosecution, apparently?
That one's
Yes, easily.
Detective Payne, I want to look at Defendant's Exhibit SS now. Don't put RR away. I think we might go back there in just a minute. But SS, if I can draw your attention to paragraph 1.
Okay.
Would I be correct in believing that I should be able to have a videotape from a place called Money's Machine?
Yes, ma'am.
Where's Money's Machine?
I don't know where Money's machine is, ma'am. It does not sound familiar to me.
Can you see the address that's also listed in paragraph 1?
Yes, ma'am.
Does that help you know where Money's Machine might be?
It'd be south of Moscow city limits if memory serves, but that's the best I can recall.
You don't know where this particular numbered address on South Main might?
So they collect evidence and don't even record where it's from, the address, the location of where they got it. That's interesting.
be?
No, ma'am.
Well, let's go back to, let me ask you this. Who do I ask where that video is?
Restate what I did before is go through the evidence custodian and Moscow PD.
Let's go back to RR for a minute. And
How would the custodian know where it's from if you guys don't even know where it's from and you didn't record any kind of documentation that certain video came from a certain location?
if you can turn with me to page,
Sorry, one more thing. It reminds me of the Delphi thing with them not knowing the name of the Purdue professor who knew he was knowledgeable in cults and runes and things like that, and he's the one that said in his report that it could be consistent with runes, what he was looking at in the crime scene. So uh, the Delphi police or Carroll County police, whoever was in charge, the police in that investigation didn't, I'm sorry, the prosecution in that investigation didn't turn that over. They didn't turn over the name of the Purdue professor. So they put it out in their 136-page Franks hearing where they laid out their theory of Odinists and cults and sacrifices and runes on top of people's bodies at the crime scene. But they hid. The point is that law enforcement hid the Purdue professor who reviewed images of the crime scene and stated it could be consistent with runes. But that's not what law enforcement was saying, or the prosecution. That's not what anybody was saying about that interview. They were saying that he said, nope, it has nothing to do with it. And then they hide him because they lied about what was in his report. And it just makes me think of that. Like, why are we it, putting evidence into our system and you don't even know where it came from and no one can tell you where to go, where to get it? This is ridiculous. It seems very unorganized like that to me. It just screams of, well, maybe we're trying to hide something. That was my whole point. Sorry for the rant.
Page 4. I'll draw your attention to paragraph number 21, particularly subparts B, C, D, and G. Do you see what I'm talking about?
Yes, ma'am.
And there, we're talking about 4 different businesses all within the city of Moscow. Is that right?
That is correct.
And those are on Main Street in Moscow. Is that also right?
Yes, ma'am.
All right. And if I read the first sentence in that paragraph, am I correct in believing that Moscow Police Department should be in possession of all of those videos?
It reads that way. Yes, ma'am.
Where are they?
I would have to direct you to the video that have been turned into the evidence lab in Moscow PD.
Is this going to be his answer for everything? I don't know. Just go to the evidence tech. I think so.
Right. I want to talk a little bit. I'm going to move from videos now, and I want to talk a little bit about affidavits and search warrants that you wrote.
Can I ask a question? You're not asking to admit these exhibits?
Your Honor, I haven't.
I just wanted to make sure.
Yeah, I haven't. The court has those in a pre-filing to put the court and counsel on notice of things we talk about. I'm not going to ask that these be admitted this way. Detective Payne didn't write them, but he's familiar with the content, so I think I have questions answered. Thank you. Let's talk about affidavits and search warrants for a minute. Did you author affidavits in this case?
Yes, ma'am.
And did you use affidavits you authored in support of search warrants to obtain information that you wanted to take a look at?
Yes, ma'am.
And did you author the affidavit that was used for the arrest warrant for Brian Koberger?
Yes, ma'am.
What did you rely on when you wrote these affidavits?
Be more specific.
Yes, let's focus on the affidavit for the AT&T records. There were 2 search warrants on December 23rd, 2022. Are you with me?
Yes, ma'am.
Okay, so let's talk about those search warrants and the affidavit. First, the affidavit. What did you rely on in the affidavit you wrote for the first AT&T search warrant on December 23rd, 2022?
It was a conglomerate of interviews, data received from cell phones, my observation of some surveillance footage that was taking place, various other things. Go down the line if you can be more specific on specific parts. I'm just happy to tell you what I like.
Okay. There was a part of the affidavit where you talked about WSU officers identifying white Elantras.
Yes, ma'am.
And there was a part of the affidavit where you talked about 2011 to 2013 Elantras, and then it expanded to 2016 to include the year 2016 Elantras.
Yes, ma'am.
What I want to know first is what you relied on to expand that search from 2013 to include 14, 15, and 16.
That information was provided to FBI Special Agent Imel, who's a vehicle identification specialist. He used snapshots from the previously mentioned surveillance videos, and that was his determination on the types of vehicles we should be looking for, rather the year range we should look for. It would be in his report, would be more specific, but that was what I based the affidavit off of, that portion of it.
But why did it change? And who made that decision to expand it to 2016? You're not, he's not answering really the question.
I understand as far as when we get to 2013, but when we go beyond that, what did you rely on to get beyond that?
It would have been his input as an expert in vehicle identification. That's what.
Okay. Part of your
So he changed his mind after you already put out there what years the Elantra was? Your expert went and changed his mind? I don't know if that really bodes well for their investigation anyways.
affidavit talks about WSU officers finding white Elantras. And I believe there was an officer that you had some communication with. Do you recall the date you had that communication?
I do not recall the date. No.
Did you have some messaging system exchange with this officer to talk about that?
Yes, ma'am.
Is that the only means of communication you had with this officer?
No, ma'am. I believe I spoke to him on the telephone as well.
When you spoke to him on the telephone, how did that relate to the date of the messaging?
It would have likely been, if memory serves, it would likely been that same day.
Okay. Does December 20th, 2022 sound familiar to you?
Yes, ma'am.
And so this conversation with this officer from Washington, it related backwards to when he noticed an alarm. Is that right?
Yes, ma'am.
But when he noticed it, you didn't know about that yet. Is that also correct?
That is correct.
Okay, so you don't know about him or talk to him until December 20th, 2022, correct?
Yes, ma'am. That's correct.
In your affidavits, did you rely on cell phone information and cell phone location information?
Yes, ma'am.
Did you work with cell phone records yourself?
No, ma'am.
Did you see cell phone records yourself?
Yes, ma'am. I did.
When was the first time you saw cell phone records that were attributed to Brian Koberger?
I do not remember what date that was.
Well, maybe you can give me an estimate. We know on the 20th, you're talking to WSU about an observation from a month before. And we know on December 23rd, you're asking for AT&T warrants for information. Can you narrow
That's
it down?
yes.
Sorry, Judge.
That's yes. You can, I just want to get the record. Yes.
Yes, that's
Okay,
correct.
thank you.
So between those two dates, does that help you identify the first time you saw cell phone records related to Brian Koberger?
Memory serves, the first time I saw any cell phone records related to Brian Koberger was after we received the return from the first search warrant.
Just to be sure I'm tracking with you, when you say the return from the first search warrant, we're talking about the first AT&T warrant.
Yes,
Is that right?
That's correct.
And in that warrant, you were seeking 48 hours worth of records. Is that right?
Yes, ma'am.
Okay. So if I call those the 48-hour records, we'll both be on the same page. All right. You wrote your second AT&T warrant for a much longer period of phone records that same day, December 23rd, correct?
Yes, ma'am. That's correct.
How far ahead of that warrant did you see the records?
It would have been upon the receipt of the 48-hour records that came in from AT&T. Immediately after receiving those, I began writing that second section of the second AT&T warrant for the longer period. That makes sense.
It does. So you get these records and you take a look at them and you start writing your warrant. Is that right?
The records were provided to FBI Special Agent Balance, who began deciphering them. I'm not an expert in cell phone records.
That was the next thing I was going to ask you.
So, no, ma'am, I'm not. So, he was the one who was conveying that information to me so I could understand what it was.
So do you get the records and then get them to him somehow?
Yes, ma'am.
The records do they go directly to Balance?
I do not recall what the distribution was on the return itself. I do not recall that.
Are you and Balance exchanging emails about these records?
No, ma'am. Not that I remember.
How did you get them to them?
We were co-located. At the time, Detective Balance was at the Moscow Police Department about 30 feet down the hallway.
Are the two of you exchanging text messaging during this time?
I do not remember if you texted during that time.
I may have a record that would refresh your memory.
If they were, then their text messages would be discovery. If that's texting back and forth, that's communication, that's notes on the case. You should be able to discover his or subpoena his phone for those records, if not turned over.
I'm certainly not seeking to have these admitted, but I'd like to hand him some records to see if we can refresh his memory. Do you recognize what's been placed in front of you?
No, ma'am, I do not.
Okay. Does reading the content of some December 23rd messages refresh your recollection about participating in text messages with Nicholas Balance?
Got receipts.
It really does not, ma'am.
Will you look at, there's 3 separate stapled documents. Will you move that one and go to the next one?
Still on December 23rd?
Yeah.
I do vaguely remember that exchange, the one at the top of the second.
Is that the one that starts with you identifying yourself?
No, ma'am, it starts with the message says, group text for this weekend, Maria, Nick, Ed, Brett, and Darren.
Will you look at that third one?
Seems vaguely familiar.
So just so I'm clear then, Nick Balance is at Moscow Police Department when you're getting, on December 23rd, when you're getting these 2 warrants. Is that right?
If memory serves, that's correct.
Okay. Well, you told me that you're not the guy who understands how to interpret these records. Do you know anything about cell phone towers?
Very little, ma'am.
So when you wrote the second AT&T warrant, you have possession of Brian Koberger's call detail records or AT&T records, but you don't know what they mean, so you're relying on somebody else.
Yes, ma'am.
Who all did you rely on?
Mainly it was Special Agent Balance. He was my main point of contact for understanding what was going on.
Okay. In fact, in your affidavit for the second AT&T report, there's a couple of maps in there. Is that right?
Yes, ma'am.
And one of them has some video camera information. That's the first map. Where did that come from?
I do not recall if you have a copy of it. I can refresh my memory and tell you.
Not that I do. I have what we've marked defendants B.
Are you referring to there's two maps, the WSU focus map you're referring to? It's completely washed out on this copy. I can't see what it is.
It's hard to see, isn't it? What I want to know is what you relied on to get that first one that talks about WSU and the cameras of WSU. So where'd you get that?
Yes, ma'am. So Special Agent Rob Hilly with the FBI was also co-located with us. He was tasked with analyzing that video from WSU and the surrounding area. So it was a conversation between he and I, pointing out areas of locations where the car was likely seen on surveillance footage. And that's what I relied upon to create that map.
So you created that map how?
Through PowerPoint, I believe, ma'am. Memory serves.
You saved your work on that?
Yeah, ma'am.
Let's go to the next map. That one would appear to be a trail or a path from south of Moscow back towards Lewiston or back towards Paul. Is that right?
Yes, ma'am.
Where did you get that map?
Same thing. It was just created using open source satellite imagery, and I think it was PowerPoint.
Did you create that?
Yes, ma'am.
Where did you get the information to draw that trail?
So that was used from the cell phone records referred to me by Special Agent Balance on his interpretation of possible places where someone could have driven between the location that it starts there and then back to Pullman.
So you did this on some open source mapping, not anything from Nick Balance creating a visual for you.
No, ma'am. I did view a draft report from Special Agent Balance to help me conceptualize this, but it did not look like this map.
Where's that draft report?
It is, best of my knowledge, it's already been provided to the prosecutor's office through the FBI channels.
Is this the lengthy cast draft report or is it a different draft report?
It would have to be the draft cast report. That's the only cast report I'm aware of from Special Agent Balance.
So on December 23rd,
Was there a draft cast report before they were given a cast report? How many cast reports are there? Is there a draft that was never seen by the defense before the current one that they have? I don't know. I don't know why she's there's something off with this cast report.
are you saying you looked at this cast draft report to make that map that went into your affidavit to get the second set of records?
Yes, ma'am.
The one that was given to us in July of last year?
I don't know when you got it.
How many versions of that cast draft report have you seen?
I've only seen that one, ma'am. That's the only one I'm aware of.
All right. And from the FBI, we have Agent Balance and Agent Hilly at Moscow Police Department with you. Yes.
Yes, ma'am.
And all of this work is done with verbal communication. Is that right?
The majority of it, yes, ma'am.
And Nick Balance's cast draft report.
Correct.
And I think Special Agent Imel's vehicle identification.
Yes, ma'am.
Okay. Let's talk about what you were seeking to get in this. Well, let me ask this before I leave the second search warrant. Is there anything else you relied on to obtain that second search warrant, to compose your affidavit?
Like I said earlier, we relied on cell phone records from surviving roommates as well as the victims. We relied on interviews with the two surviving roommates that were present at the time. We relied on the surveillance footage, cell phone data. I'd have to go paragraph by paragraph, but that's what jumps to mind.
But did you actually look at the data that you had? Did you actually pinpoint all the areas that Koberger went that night with his phone? I don't think that they did. I don't think that they actually did it. I don't know. I don't think that they actually retraced the steps of Brian Koberger from that night. I think this is just a guess that they have, and that's what they're using to base their affidavit on, his affidavit. He wrote the probable cause affidavit that has so many errors. That's what they're going over. She's making him look at certain parts of the affidavit, which is what he said he saw probable cause for. So he swore to it, and he's got to defend it. If there was really probable cause, it's up to him to defend right now. I mean, he's not on trial for it or anything, but he does need to defend that probable cause. And if we do go to trial on this, she's gonna be really hammering home on the probable cause.
Of those things, are you relying on other people's work to put that all together?
Yes, ma'am.
Okay. Now I'm ready to talk about the things that same day as the first one. And was there anything else from AT&T that you saw or relied on to get the second one off the ground?
No, ma'am.
And in the first AT&T search warrant, are you aware that part of the request was for timing advance reports?
Yes, ma'am.
And in fact, that also appears in your second search warrant request, right?
Yes, ma'am.
All right. And not only do you ask for the timing advance reports from AT&T, you ask for them from several other companies, correct? Verizon's version of it, T-Mobile's version of this kind of timing advance report. Is that right?
Yes, ma'am.
All right. When was the first time you saw AT&T's timing advance report?
I do not recall when I first saw it.
Where is it?
To the best of my knowledge, all that information from those returns has been provided to the prosecutor's office.
If I tell you I don't have a time,
That sounds like such a coached answer. To the best of my knowledge, everything's been provided to the prosecution's office. Like he couldn't get that sentence out fast enough. He'd been practicing that for the whole morning in the mirror.
advance report or any from the other phone companies, where do I look for them?
I would direct you back to the prosecutor's office. Everything that Moscow PD received, we, in that realm, we have turned over to my knowledge.
But you know you've seen this report. Is that right?
I do not recall if I've seen the timing advance reports. I'd have to see what it even looked like to know if I'd seen it.
Do you know what it is?
Not particularly. I'm no expert.
Okay. You wrote the search warrant though, right?
Yes, ma'am.
Well, how did you get the language for that if you don't know what this is?
So
Yeah.
there's no secret that I rely heavily on people who are very highly educated in these topic areas to write the search warrant. So that language was likely conveyed to me through people who know much more than myself about cell phone data.
Who are those people?
Like I said, FBI agent Balance and Detective Mowry were probably my two main points of contact for helping me with that language.
And if they were going off of some kind of report or something, like what were they using to determine the things that they came to? And what's their experience? What is their background? Something that really I became aware of watching the Karen Reed trial. And I mean, I've already known this, but it's just very, very concerning when it comes to law enforcement and their experts versus an outside third party expert who is hired specifically for that thing. And that's the only thing that they do. Whereas law enforcement, you're a cop and you take some classes in something, and now all of a sudden you're a DNA expert. So the experts in law enforcement who do the data extractions and things like that, they might not have the background or the knowledge or the skills to even be doing these things. And they're putting people away. They're locking people up. They're taking their freedoms away. They're taking away their civil liberties and all their constitutional rights by putting them in prison. I'm not saying that that's what happened in this case, but it happens all the time. It happens so much more than we want to believe or accept. I'm angry. No, we're not playing. Why is it? Play.
During the course of
Oh.
your investigation and work on the case that became the case that we're here for now, did you communicate with Agent Balance by email?
Yes, ma'am.
And did you communicate with other FBI agents by email?
Yes, ma'am.
And did that relate to the investigation of the scene and later the investigation of Brian Koberger?
Certainly, yes, ma'am.
Were those communications that assisted you in preparing affidavits and search warrants to carry out your duties in the case?
I do not recall.
But you recall the emails themselves
I recall sending emails to FBI agents, yes, but
And-
specifics, no.
and receiving them?
Yes, ma'am.
Where are those emails now?
All emails that Moscow PD is aware of have been turned over to the prosecutor's office.
Your Honor, if I could have just a minute.
Sure, thank you.
Canned answer for everything.
Front end, if you don't need them for us, maybe I'll take them back.
Well, hold on. Do you have any questions?
Yes, I'll-
Yes. Okay. If I was just stepping on, so.
To your knowledge, has all the evidence in Moscow Police Department's possession been turned over to the state for us to discover?
Yes, ma'am.
Have you facilitated the defense visiting MPD to review the physical evidence in this case?
Yes, ma'am.
This is now Ms. Jennings, I believe her name is. For the prosecution side, she is asking questions. So she's on cross, talking to this witness, Brett Payne.
Approximately how many times have you done that?
I had to guess, I'd say 6.
Now, let's talk specifically about this video surveillance. Explain to me the process for collecting video surveillance.
So in this investigation, the way that played out was we directed the investigators to go into the community and collect any available surveillance footage there was. Once they had done that, they were tasked with bringing it back to the Moscow Police Department, placing it in the digital forensics lab, and then writing a supplemental report on where they collected that information. That was the process.
Do you know how many agencies helped in this video canvassing?
Certainly the FBI and the Idaho State Police. I'm not sure if any other agencies helped. I don't know.
Do you know approximately how many agents were out collecting video?
Easily over a dozen. I don't know a specific number, but
Isn't it true that investigators collected video surveillance from approximately 79 businesses
Yes, ma'am.
and approximately 10 residences? So let's talk about the areas that Ms. Taylor mentioned. Isn't it true that there's other surveillance video capturing the Moscow-Pullman highway, specifically on the way to Pullman?
Yes, ma'am. There is.
Isn't it true we've turned over video for banks
Yes,
on
ma'am.
that highway? Isn't it true we've turned over surveillance for stores on that highway?
Yes.
Isn't it true we've turned over video for gas stations?
Yes.
Now let's
That's great that they're turning over all this video, but where's the sorry, I just lost my train of thought because Karen Reed trial, they're back in the court and I want to look at it in just a second. So that's great that they have all these videos and they turn them over, but where's the evidence that Brian Koberger was in any of them? That's what I want to know. Was he doing the route that they say he did to the Moscow home and then um on 1122 King Road? Did he go there? Do you have him on video going there? Like none of this is proving anything anyways. If they have this video, I guess it's missing is the problem, or uh and Taylor hasn't received it.
talk about the Troy highway towards Troy. Isn't it true we've turned over surveillance video for fast food restaurants,
Yes.
gas stations,
Yes.
and now US 95 towards Coeur d'Alene? Isn't it true we've turned over surveillance video for hardware stores,
Yes.
gas stations?
Yes.
Now, what about US 95 towards Lewiston? Isn't it true we've turned over surveillance video for gas stations,
Yes.
as well as apartments?
Yes.
Now let's move to your PC affidavit. Can you explain to me what did the investigation look like during the time that you were writing that affidavit?
So as I said, the command center was established at the Moscow Police Department. The command center consisted of myself and numerous partners from the FBI and the Idaho State Police. We were all co-located there at Moscow PD. We also had individual sections assigned to do various tasks, collect video, conduct interviews, so on and so forth. The majority of those people were also co-located at the Moscow Police Department. So as the process for developing this affidavit began, those people would just come into the command center and relay information that was deemed to be critical or important. The reason for that was to shorten the chain of information to make sure that the folks, myself and my partners in the command post, got the clearest view of what the investigators on the ground were actually retrieving and learning as this went on. As they relayed that to me, I can put that into the affidavit.
And is that standard to rely on what other investigators tell you when you're applying for warrants?
Absolutely.
And is that what you did?
Yes, ma'am.
And is what you relied upon detailed in your probable cause affidavit?
Yes.
Now, talking about the timing advance records, are you aware that AT&T didn't provide timing advance records in December 2022?
I do not remember.
Are you aware that they did not start providing those records until May of 2023?
Objection, Layton.
Cross-examination.
It is overruled. Go ahead.
I'll re-ask. Are you aware that AT&T did not start providing those records until May of 2023?
Yes.
I don't have anything further.
Thank you. Ms. Taylor?
Thanks. Let's start there. May of 2023. Do you have timing advance records now from May of 2023?
I would have to direct you to Detective Mallory to answer that question. Don't know.
Okay. Did you write a new warrant for them in May of 2023?
I do not recall.
If you included them in two separate warrants in December of 2022, but they didn't provide them, why did you do that?
It was the language that was suggested to me to write the affidavit. So
Language suggested by an FBI agent who's an expert in the field?
yes, ma'am.
Yes. And do you know if he saw the timing advance reports?
I do not know.
All right. Now, those first and second AT&T warrants were how many hours from receiving the return on the first one until the second one was given to Judge Marshall at 4:45?
I do not remember.
Not very many hours, though. Would that be fair?
Likely not.
I want to talk a little bit more about the video and what's been turned over and what hasn't been turned over to us. And I want to focus a little bit on South US 95. Do you recall that south of Moscow on US 95 is the path that you put in your search warrant and affidavit alleging that Brian Koberger left Moscow going south on US 95?
Yes, ma'am.
All right. And are you aware that one of the videos that you gave us, the coffee shop there on South 95, that leaving Moscow, you have to pass that covers 5 a.m. to 6 a.m.?
I do not recall the time frame for that.
And so the time frame in these videos would matter, right?
Certainly.
Mm-hmm.
The time frame in the videos to be meaningful would need to cover a time.
The time frame in the videos is 5 to 6 a.m. and that's the original time frame that they all said the homicides happened. Then they took it back and said it was like between 3 and 4. right? So now what? Or or between 4 and 5, maybe. The hours are critical, and when you obtain the evidence from the videos along your routes that you go and investigate and get ring cams and surveillance cams and whatever, you're going to be asking for a specific date and time frame. You have to ask for a specific time frame. You can't just say all of it. I mean, that would be ridiculous. So obviously they were originally looking at 5 to 6 a.m. in this investigation. And this that shows because that's when they were seeking the video footage.
That surrounds the allegations against Mr. Koberger. Is that fair to say?
You can say that, yes.
Okay. And are you aware that Watson Kari Construction had a video, and that also has a very limited time frame, like 5 a.m., just 1 hour of video also?
Sounds vaguely familiar, yes.
And that's also south on Highway 95. Is that right?
Yes, ma'am.
And the one we talked about today, Monday's machine that nobody could find, that clearly was given to Moscow Police Department, that's also south on 95.
Yes, ma'am.
Okay. I understand that you had a lot of help on canvassing and collecting things. There was a lot to do. But as the lead agent and the lead department, is there some kind of inventory of these videos, like a general inventory that would help me know what you have and why you don't have the relevant timeframes?
The inventory that would be most useful to you is the inventory of evidence that has been booked into the Moscow Police Department. That's the inventory.
And I did come see the evidence. That's fair. I did come see the evidence. We didn't watch videos together, though, did we?
No, ma'am.
And would you agree that that evidence is on thumb drives with stickies on papers that tell us different things, but not like an inventory of what's on each thumb drive?
I am not aware of an inventory of each individual thumb drive.
Okay. So for us to do that together would take some days to inventory it all together. Is that right?
Yes, ma'am.
And that's my best way to try to find this Monday's machine.
Sure.
And Watson Kari Construction.
Yes, ma'am.
That's it. Thanks.
All right, Ms. Taylor, you can follow up on that. Jenny?
So you don't even have a record of your own inventory, and you're going to make the defense go and make one of their own. What is happening? What day and age is this? Do we not have computers where we can log things very easily? You can even like check a box when it comes in or goes out and put initials on it and make forms and all sorts of things. We have the capability to do that and to track these things. Yet it's not being done. Why? It really makes me wonder why.
Oh, just one second.
The lawyers are conferring
Thank
with
you.
one another.
I just want to clarify what's in your probable cause affidavit. Does your probable cause affidavit state that Koberger or White Elantra went on US 95 south of Moscow?
No, it's not.
Okay. What does it state?
Memory serves states that the next time, well, it states that a vehicle was seen leaving the area of the crime scene, McKean Road, leaving via Walenta Drive, which heads south.
It was seen from what? From where was it seen leaving the crime scene? What video do you have of it? Who saw it? Tell us. That's the problem here. He just says we know it left the scene. Well, you didn't explain to us how it left, how you know that fact. How do you know that he left the scene? How do you know that he was near King Road? That's the biggest question.
On that area, and then terminates on Conestoga and Blues River Drive. That's what the probable cause affidavit states.
And to your knowledge, are there other paths of travel south of Moscow besides US 95?
Yes.
And what's that other route?
I believe the one that was referenced in the affidavit goes from Blues River Drive, which turns into Sand Road at the state line, Idaho, Washington state line. That road continues westbound until south of Pullman and eventually leads north into Pullman at Bishop Boulevard, if memory serves.
And does that path of travel go by Watson Kari Construction?
I do not believe it does.
Did you attempt to obtain surveillance on that path of travel that doesn't go through 95?
Yes, we did.
And were you successful?
I don't believe we were.
I don't have anything further.
Okay, thank you. Ms. Taylor?
Are you testifying that Mr. Koberger did not use Highway 95 south of Moscow on November 13th?
I'm testifying that there are various routes that a person could take south of Moscow to include Highway 95. There are also several others.
Which one does your map depict?
I believe the map starts well south of Moscow, or more towards Gen C, and there is the line that starts there. However, I would direct you to the paragraph at the beginning of the map that says this is a possible route of travel between the two locations.
So you're just not sure.
Yes, ma'am.
Okay. That would include then Highway 95 south of Moscow.
Yes, ma'am.
And that would include other possible.
If you have all this video surveillance footage, you should be able to replicate his path of travel, should you not? I mean, is that not what the point of getting all this video surveillance footage was? To find the white Elantra and to watch it on its path? But yet, we can't find the videos. They're hidden somewhere, or we don't have an index, so we can't look. And we have no way of knowing what anything is unless we actually search through the data and make our own index. This is ridiculous. And this just happened, it doesn't just happen in one case. When there's this much like negligence, or I don't even know what you call it. Is it negligence? Is it corruption? Not really sure. But when there's this much of it, whatever it is going on, there's a big problem. And it appears that there's a lot of things that they try to keep hidden about this investigation. And it sucks for the public wanting to know. It sucks for the families who want justice for what happened to their loved ones. And they just keep dragging it out and not providing the discovery that they're requesting, or making them jump through hoops to find it. It shouldn't be like this. This is a big problem in our justice system.
Yes, ma'am.
How many video surveillance attempts did you make to get video from businesses or homes on all of those routes?
I do not recall, but it continued for some time, attempting to find additional video footage.
What did you find?
Nothing to my recollection.
Not one video depicting the car.
To my memory, no.
Good enough, thanks.
All right. Thank you.
So not one depiction of his car on any of these videos that are supposedly missing or whatever. No one's identified Koberger's car anywhere.
Okay, great. Can this Detective Payne be excused at this point?
He can be, thank you.
Okay, any objections? All right. Thanks, sir, for being here. You can, you're free to stay or leave.
Thanks, sir.
Thank you.
Your Honor, we call Cyray.
Okay, thank you.
And we got some DNA expert, I think. Isn't he DNA expert?
Thanks, sir. Thank you.
Do you solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth, and the penalty of perjury?
Right. Thank you. So you go ahead and have a seat there, and then please state your name and spell your last.
Cy Ray, R-A-Y.
Thanks, sir. Ms. Taylor.
Thank you. Good morning.
Morning.
Will you tell us what you do?
I have a handful of different jobs, but primarily for my role here, I do a lot of consulting, analysis, and evaluating geolocation data as it pertains to mobile device.
Let's talk about how you got to that place where you provide consultation on devices and geolocation.
Okay.
What background led you to this job?
I started with a law enforcement background. I started my law enforcement career in 1995 in Arizona. I started working with the first set of cell phone records in that capacity in 97, late 1997. There wasn't a lot of training. Obviously, cell phone technology and the use of that in criminal investigations was very new and novel at that time. So most of my early training came directly from the carriers. If I was working a case with Verizon or AT&T, I would work directly with Verizon or AT&T engineers to understand the records, what they meant, how to map them, how to interpret them. In 2000, I started a very small police department in Arizona. In 2000, I transferred to a much larger police department in the Phoenix area. When I made that transition, I took more of an investigative role. I was previously a patrol officer. That investigative role, I started with a DEA task force where I worked with drug narcotic interdictions, and the primary role there was working with cell phone records. So I had some more training experience in that capacity. In 2001, late 2001, I left that position and I went into a full-time investigations position. I started with sex crimes and child crimes. Again, using cell phone records and attending what training was available. Again, most of that is from the carriers directly. About 2004, I moved out of sex crimes and child crimes into persons crimes or violent crimes. So any type of a dangerous or violent crime against a person. Continuing to work with cell phone records and attending what training I could. In 2008, I was promoted to sergeant, and I was immediately put into a homicide robbery sergeant's position, where I stayed until 2010. Around 2004, I started doing a lot of work with cell site simulators, and that is a piece of equipment that allows you to physically go out in the field and find a mobile device. In a very brief summary, it's the ability to create a fake cell tower that is mobile, it's in a vehicle. And if I can analyze your phone records and determine a rough area that you're at, I can put this mobile platform in that area. Your phone will register to it, and I can physically track the phones. It's in courtrooms, it's in a bedroom, wherever it may be. In 2007, our agency purchased that equipment. So prior to that, I was working with other agencies looking for devices using it. 2007, we purchased our own equipment. That purchase also prompted more training. There was a company, it's owned by Boeing. They came in and I had 80 hours at that point specific to cellular network engineering, how to go out and actually conduct these surveys to understand how a particular cell phone network works in a particular area, how to replicate, how to create a cell site that looks legitimate in that area. I worked at that company for a number of years in doing that, hundreds of hours worth of back and forth working, actually going out in the field and doing this. In 2010, I had an opportunity to go to Afghanistan as an advisor in charge of an undercover Afghan police team that targeted IED cells. And again, we would look at different types of technology that we could leverage in doing that. I came back in late 2010, early 2011, and went back to the police department. In 2012, our department created a position that this was a full-time position. That's all I did was track phones pretty much every day, using cell site simulators, using phone records, whatever technology we could leverage. Because of the lack of training that was available when I was a younger officer, in 2007, I started a training company. At the time, it's called Phoenix Training, and I created a training company to provide law enforcement training, specifically as it relates to cell phone records. I've been providing that training from 2007 up to about 2013 now. I was really frustrated with the lack of software and training available to law enforcement. It's very complex and clunky, for lack of a better term. So I began researching and teaching myself how to do some basic computer programming, and I wrote a program that I could take phone records from any carrier in the United States, and I could put it in this program, and it would immediately map hundreds, if not thousands of connections. It was pretty unique at the time. There just wasn't a lot of options out there that was doing the geolocation. There was a lot of analytics to who's calling who and how often they call that person. But specifically to put it on a map for detailed geolocation data, there was a big gap in the market. It worked really, really well. And at the time, because we were tracking phones in the field, it gave me this very unique opportunity where I could use a search warrant, get phone records, analyze the phone records, come up with a hypothesis that this phone is most likely Thursday at 2 a.m. going to be in this neighborhood, and then physically go to that location to recover the phone. And then I could evaluate, was I right? Was I wrong? Do I need to tweak something? Mid-2013, our agency was assisting a lot of other agencies because we had, for lack of a better term, we had progressed significantly on our ability to find phones. I had a lot of agencies asking me for a copy of my mapping program, and I was just about 20 years at that point. I realized maybe it's time to go do something else. So in May of 2014, I retired from the police department, and I started a company called ZETX, ZETX. And we offer a couple of things. So we have the mapping program that I just described. Obviously, when I'm running it on my laptop, it can be a little clunky. It doesn't have to be perfect. When we started business, we actually hired computer engineers to come in and take what I've written and scale it to a national platform. So we offered the mapping services, which was both real-time and historical. We took that original training class that I had built and we scaled it out. So we had a basic 40-hour that would just give you the nuts and bolts of how to look at phone records, what they need, what type of records to obtain. We also started a subject matter expert course. It was one of the first courses in the country where law enforcement could actually come in and become certified as subject matter experts in this field. Did some training courses as well that we created on drive testing, so the ability to go out and scan and monitor cellular networks. Because of those two features, my job duties changed dramatically, where I found myself consulting with law enforcement daily, sometimes multiple times in a day, on cases very similar to this case, where I would have a law enforcement agency that's using our product or has attended our training that would call me for some type of review or analysis. And I've lost count of thousands and thousands of cases. To put that in perspective for some just general numbers, I sold this company in 2021. At that time, around 2021, 2022, the system had mapped over 2 billion phone calls in the United States. We were seeing thousands of uploads a week. We had created this program in 2014 that if any law enforcement agency in the country called us because they had some type of crime, we would overnight them a drive test scanner, which gives them the ability to go out and do a forensic examination of cell tower networks. It was no cost. We ate all of the costs. So we paid for the scanners. Initially, we paid for the shipping. And the idea there is we wanted to create a national tower database that would have just a collection of drive tests. I want to say we have over 3 million towers in that database today that have been scanned or measured in some capacity. I am unaware of any other database in the world like it. And we use that to feed the mapping platform to increase the accuracy of the mapping. Something that we did that was very unique with our company is we actually provided an estimated coverage area. So instead of just saying this phone connected to this cell site and the antenna points north, we would give the person doing the analysis a general idea of where that phone could possibly be within a radius. We were the only ones doing it when we did this. Since then, since 2014, more recently, since about 2020, pretty much the rest of the industry has adopted, if not the same standard, a very similar standard. So the company we were using to do the drive test data is a company by the name of Rode, ROHDE, and Schwarz, SCHWARZ. They're a German company out of Munich. They've adopted the way that we were doing some of the ranging. The FBI task team has adopted that, has actually brought that tower density is what is the general term for it, and it's now featuring the CASPIS program. So through the years with training, I've probably been involved in training 30, maybe 35,000 law enforcement officers from around the country. We have about 650 law enforcement agencies within the United States. At some point, all of the federal agencies have used our products in their training, and I've done quite a bit of consulting internationally as well. Towards the end of that period, we started working more with Rogan Shores. Rogan Shores decided that they wanted to look at the ability to implement a cell site simulator in the United States. They had one for Europe. They were considering doing it for the United States. So they sent me their first one for the United States, and I worked with their engineers for about a year, testing it, reviewing it, improving it. So another several hundred hours there. I tried to figure out how many of these missions, if you will, going out and finding phone or looking at phone records. And it is literally thousands and thousands of hours at this point. I can't tell you specific number. But that would be the background.
Sounds like your background is mostly in law enforcement, and then you moved into a specialty with cell phones, cell towers, drive testing, radio waves, all kinds of things.
That would be correct.
Through that and through the training of other officers to do this work and to use your program, have you testified as an expert in this field?
I have. If it's not 100 times, it's right there near it. Roughly 100 times in both state and federal courts.
And have you been qualified as an expert in state courts?
Yes.
In federal courts?
Yes.
How about Idaho?
Don't think I have in Idaho. I've consulted on a lot of cases in Idaho, but I don't think I've ever had testimony in Idaho.
This your first time then?
I believe it is.
Generally, when you work, and I'm talking about when you've done your consulting work or worked with an agency to do what you do to review the records and to analyze the data, do you usually work with the defense?
This is the first time I've ever testified for defense.
Fair to say you usually are a prosecution witness?
That is a very fair statement.
Well, here you are, and you're working with us in Mr. Koberger's case. What's your role in this case?
Trying to conduct an analysis of all of the geolocation data. At this point, still focused primarily on Mr. Koberger's device, ultimately all devices, but any geolocation data, which is the ability to look at a specific area, whatever range or size that might be at a specific time, and put some type of accuracy and reliability to a phone's travel. Maybe it's static, when it's moving, when it's not moving, when it's off, it's on, those type of things. But specifically as it relates to networked, so the cellular network or a Wi-Fi network, I'm not a forensics digital guy. I don't get into cell extractions. I'm not looking at the metadata on the phone. I'm looking at it very much as a network tool.
If I can make a rough distinction, you're not the person that's going to tell me who they called and which Facebook groups they might be a part of. You're not going to look at the data from the phone like the photographs, but you're going to tell me the places this phone went and how it was used while it went somewhere.
Kind of. Let me clean that up a little bit. I will look first at where I believe a phone went, where it traveled, how it got there, how long it took, possible routes. And then to your point, I call it cooperative data. I'm then going to seek out all that data you just talked about to say, okay, we have these 3 photographs, we have this piece of surveillance video, we have these 4 receipts. I'm going to overlay it with my analysis so that I can corroborate the analysis accurate. Or maybe we see activity associated with that person and the phone's not there. Does that person just not have the phone, or is part of our analysis wrong? Maybe surveillance details wrong. We don't know. So eventually I will get back to that data you're talking about, but I'm not the guy that's going to go out and extract that data.
Would it be fair to say that that's data that you would use in a final analysis as it comes in from other sources, that you're the go-to for me to understand how a phone works with a tower and how it moves between towers if the phone's in motion somewhere?
Yes, 100%.
You talked a little bit about drive test data or drive testing and that being part of the company that you developed and part of the work that you've done. Is that helpful in understanding the ultimate picture?
Depending on the type of records we're dealing with, it can be very helpful. When we're looking at just basic call detail records, CDRs, a lot of times we're just getting connections to a particular cell site, and we can say a site of that cell site. Sometimes the frequencies that are used. Drive testing is really the only way to get a little bit more specific with where that phone may be. But more importantly, we can start to rule out areas we know it's not by drive testing. So just think of drive testing as a forensic evaluation of the actual cellular network in a particular area.
Fair. Are you familiar with AT&T records?
I am intimately familiar with AT&T records.
How long do you think you've been working with AT&T records?
28 years.
In our case that we're here on today, have you reviewed any AT&T records that relate to Mr. Koberger?
I have.
What have you reviewed?
What AT&T refers to as their regular CDRs, which is a report to AU as an atom unit. I have identified the report CT as Charles Tom, which is the subscriber information. There's a really weird name called Locabor, which is AT&T's attempt to estimate general locations using latitude and longitude. I don't want to say GPS because it is different than GPS. I believe I've looked at some ping data from December. For the most part, that's what I've reviewed so far.
Have you looked at 2 separate AT&T warrant returns from December 23rd, 2022?
I have.
In your experience with working with AT&T records, is it common or uncommon to have 2 warrants, one that relies on the content of the first in the same day?
It's not uncommon to see a small time period that produces results that would increase the desire, the need for a bigger time period of records. Seeing that entire process happen twice in the same day is extremely rare.
The first AT&T record, we called it today the 48-hour AT&T record of Brian's call detail record. If you were to take that and do an analysis on a call detail record, how long would that be?
Depends on the analysis. So I'll qualify that answer with looking at what was put into the second warrant. That shows us at least parts of that analysis to include a route that was identified. To do it reliably and feel comfortable that I'm accurate, at least 3 hours. And that's if you know what you're doing and you have all the tools at your disposal. Arguably, you could spend half a day or more doing that very easily.
To do that, do you just take these records, printed copy, and know what's on there, or do you have to do something with those records?
You have to use some type of a mapping platform software, and you would take the digital copy, which is typically a text file. You would import it into that program, which would then map everything. But if I'm going to use those results, search warrant affidavit, for example, there's a process that I'm going to go through to confirm the accuracy. Because in theory, if I'm wrong, the entire linchpin of that case is now hinged on this affidavit that I wrote. So before I commit to swearing out to an affidavit, hey, this is what the phone is doing, X, Y, and Z, there's a further process of just mapping it to validate it. In this case, there's a lot of time distance measurements that need to be performed that can be extremely time consuming. There's some ulterior issues that come up with how that phone is interacting with other cell sites that needs to be analyzed. Again, saying that a very qualified, competent investigator spending half a day just coming up with that basic summary is very reasonable.
In that half a day, you would put that record into a computer program and a map would be produced?
Correct.
What other information besides that call detail record would you need to do this analysis?
In this case, I would want the call detail records. I would want the lookup board. It's LOCABR. And I would want the regional cell tower list from AT&T.
Does AT&T generally provide that regional cell tower list inside of its record that it produces pursuant to the search warrant?
No, I would actually say by policy, they do not. It's a very large file. It typically does not transmit very well to government email. So they would direct users of where they can go online and download.
And have you looked at this record, the 48-hour AT&T search warrant record, the return on that?
I have.
Did that include the regional tower list?
It did not.
Okay. So if you are doing this analysis, you put ZDR records into a computer program, you put a regional tower list into the computer program, what does it produce?
The CDRs would show me cell sites that the phone connected to. In this case, even within 48 hours, there's hundreds of those cell sites. So it would take a while to really look at that. The regional cell site list would show me the cell towers that the phone's not interacting with, which can be just as important.
Does it spit out product to you, or does it create something that you can reference to write your next warrant?
Depending on which mapping platform you're using, they all create some type of a map that the person doing the analysis on can interact with, and they can change things, they can save things, they can create work product. Depending on that platform, that's saved in different types of maps, but yes, all of them would have some type of a mapping platform.
Okay. Would that be consistent with this past draft that we heard about earlier?
It's my opinion that Corporal Payne probably is misusing some terms there. I don't see any possibility of the FBI CAS team producing a CAS draft report on the 23rd. I think he's probably mistaken that he saw some type of CAS work product, which would be this map, before they export all those results into a report. So I believe that he probably saw some mapping through a mapping platform. It would really surprise me if there was a physical report. It would be completely out of character.
In that first AT&T report, did you request search warrant affidavit? Did you see the request for advanced timing reports?
It's in both search warrants.
Did you get a copy of that in either return?
I have not seen any timing data in this case.
In December of 2022, did AT&T have this advanced timing report?
They absolutely did.
Was it something that they could produce?
It absolutely was.
And in May of 2023, how's it different than for 2023?
Prior to May of 2023, only certain agencies were receiving this timing report, the FBI being one of them. What was referenced earlier about the May 23 date, that is when AT&T started offering the same type of reports. It's a little different, but it's the basic timing report to the state and local law enforcement as well. But prior to that date, state and local law enforcement would have to leverage these reports through federal agencies that had access to them.
Let's talk about the return on the second AT&T warrant. Did that have the tower list, the regional tower list in it?
It did not.
Did it have call detail records?
It did.
What time span?
I believe it's from June 23rd of 2022. The historical was as of the date of December 23rd, but there was also a real-time pin register that was added that extended, I want to say, to the end of December, maybe very first of January.
What's a real-time pin register?
So the second search warrant asked for a couple of different things. Historical records going back to June 23rd to the current date, which was December 23rd. The second piece that was asked for is real-time data from the network, which is commonly referred to as a pin register, trap and trace. And it's the ability of law enforcement to monitor network connections in real time. So as that phone connects to the network for certain reasons, I can actually I can see those connections. It's not a wiretap. I can't hear anything. I can't see content, but I can tell the phone is connected to a particular cell tower. There's also what's referred to as ping data, and that's going to be AT&T's estimation of where the phone is at, and that's provided by latitude and longitude, and that comes in every 15 minutes.
What is the purpose of one of those devices?
I should probably clarify. The third thing was the authorization for a cell site simulator. So it was a combination of all of these. Just as a matter of policy, and I think pretty much every law enforcement agency in the world has adopted this if they can. To use the cell site simulator, you want to see a real-time feed of the phone. Otherwise, you're driving in circles where the phone may not be. So it gives law enforcement the ability to have a general understanding of where a phone is operating or functioning, and then I can use the cell site simulator to do it. There's a number of reasons an agency might do this. This report actually says they were requesting it because they were trying to locate where Mr. Koberger was.
Going to the understanding what's happening right now, is that used so that you don't just know where the phone was 5 minutes ago, but you know where it is right now?
Within a time period, it's not a perfect system. There is a little bit of delay, and the information comes in intermittently. So it's not a real-time feed of giving constant evaluation of where that phone is. But if you know what you're looking at and you've done it long enough, you get a pretty good idea.
I heard you say that this is to try to find out where Mr. Koberger is. In the information that supported this warrant, didn't they already know where Mr. Koberger was?
I reviewed a lot of documents that clearly state not only did they know where he was, they had a surveillance team with eyes on. So yes, it would be unusual for an agency to request this type of equipment. And I need to qualify that. This truck driving around is about $1 million. It's not something you just park in the garage at night. It's a very expensive resource. It's a very technical resource that requires a lot of training and skill to use properly. So typically when it's used, it is used for, hey, we don't know where this person's at and we need to find them. And to be very honest, I don't have an issue with that part. I've used it. It's a good tool. It's a great tool. However, if I know where a subject is and I'm physically watching him, it's probably disingenuous for me to get a search warrant justifying it that I need to find him.
Makes sense. Thank you. I want to switch gears and talk about the CAST-BIZ program. Okay. Are you familiar with the CAST-BIZ program? Why?
I've worked with a lot of agencies that have used it and accessed it. So I've worked on cases where we've used different mapping platforms to do kind of a compare and contrast as a peer review. So they would create a work product, we would create a work product, and we would check each other's work. Because at the end of the day, we're just looking for the accuracy. We want to see if there's any errors in that. I would say I probably have worked with the CAST-BIZ reports several dozen times, maybe 50. I'm aware of some of the updates they've made. Like I mentioned earlier, I'm aware that they have added a feature that you can now input tower density, so you can create these estimated ranges, if you will. And I'm very familiar with the basic settings that have certain controls you can do, like time zone. What time zone am I going to have? Am I going to use the coverage density? Am I going to save my work? Am I going to just exit the program? I physically have seen those features a number of times.
As it relates to this particular case, have you had a chance to look at any exhibits prepared by Detective Mallory using the CAST-BIZ program?
Yes, but I should clarify. One of them I'm pretty familiar with. I believe it's State Exhibit 48 that was used for the grand jury. The others I had never seen until I believe it was last week. So I'm probably going to have to look at those if you're going to ask questions on those. But State's 48, I'm pretty familiar with.
I want to ask you a question about that. I'll ask you some other questions about the records we received last week. I'm going to have you handed what was admitted last week as States R, just my copy of it so that you know what we're talking about here.
Okay.
I'm curious about what was needed to go into CAST-BIZ to create that.
So when I open the CAST-BIZ program, I have to input what I'm going to refer to as source data. So let me define source data is any data that is an electronic format, typically a text file, that the CAST-BIZ program is going to link to this mapping session and use that source data to create the images we're seeing. I can tell you right off the bat, without a doubt, this one is linked to two different source data. One is going to be a set of CDR records, so the regular AT&T CDRs. And then this particular exhibit would require the regional AT&T tower list, which is a text file that contains all of the cell site locations, most likely be Western Washington, Idaho, and Eastern Washington, Idaho, and Western Montana is typically that region. But there's no way this map was created without the AT&T tower list. It's physically impossible.
Is the AT&T tower list, was that contained in the call detail records that were obtained by search warrants relating to Mr. Koberger?
It was not.
All right. And in the CAST-BIZ program, when you input the CDR call detail records and you input the tower list, does that program create any type of log?
It does. And I want to make the record really clear on what I'm testifying to, because it can get kind of confusing when we start talking about different versions. The CAST-BIZ program offers two styles of mapping. I can just default to a normal size, what they're going to refer to as a wedge shape, which is representing the sector the device connected to. If I was doing that, all I need is the AT&T records, because the AT&T CDRs actually have the tower information that's required for that mapping. As soon as I change that feature, though, to add coverage areas, the estimated coverage areas, and now these little wedge shapes or these sectors are all different sizes, the CAST program has to be linked to a tower list that has location of all of those towers. That's the only way the program knows how to size the cell sites. So I just want to clarify, if I'm mapping the CDRs without coverage areas, all I need is the CDRs. If I'm mapping the coverage areas in the CASPIS program, I have to have a tower list. This one, I can see 3 different sectors. 2 of them, if anybody sees this exhibit, just to make the record really clear, they're really hard to see. One of them is just under the N as in Nora, under the word Pullman. The other one is right by the L in Pullman. But they're different sizes. And that tells me right off the bat that the AT&T tower list is used.
And why are they different sizes? Might be good.
Cell tower density. We see a great big sector right in the middle of this map. And I'm not familiar with the area here. It's basically south of Pullman and south of Moscow, kind of out in the middle of nowhere. Not a lot of cell towers out there. So one tower covers a very large area. Then the other 2 are going to be in Pullman. It's kind of hard to see on this map, but I believe they are going to be ones that are on Washington State University campus. A lot more cell towers. The coverage is much smaller. So it's just a way to look at tower density to kind of estimate how far certain towers may connect to a phone where others may have a very short range.
And is it based on that difference in towers that causes you to know that a certain type of tower report was used?
Yeah, it is a basic algorithm that uses tower density. And the only way to determine tower density is to have a list that has all of the towers, not just the ones that were used by the cell phone.
Okay. Do we have the list of the tower list that was used by Detective Mallory in developing that exhibit?
Detective Mallory stated he did not use a tower list to create this exhibit. So no, but I'm not sure how to answer that other than I haven't seen one.
Should it be there?
It is physically impossible to create this map without it.
If you had the logs from the CASPIS program, would that give you more information about what was used?
It would. We would need the CASPIS program as well. The logs are saving certain settings, and it's a JSON format, which is just a software language. We could load that JSON file into the CASPIS program, and for the most part, we could replicate exactly what was done.
If I understand that, to turn it around, in order to replicate that and to see what was done, you would need a CASPIS program. Is that right?
Correct, and preferably the same version that was used.
And you need a JSON file that was made by Detective Mallory. Is that right?
Correct, and depending on where the software program is, we would probably need the source data again because it may not be automatically linked. Anybody who did PowerPoint 10 years ago, you make a PowerPoint on one computer, you save it on a thumb drive, you go to a different computer, all the links are broken. It could create a situation like that. So you probably need the original source data as well, just to be sure.
What's the original source data?
In this case, it would be the AT&T CDRs and the cell tower, the regional cell tower list.
From that time?
Correct.
Okay.
Well, no, if we're trying to recreate this work, this is where it gets a little complex. We would need the exact AT&T tower list that Mallory used but didn't use, which makes it really difficult because AT&T updates these on a fairly regular basis. If he used a November list and I use an April list, the results could be different.
Okay.
Oh, that's bad.
Why would the results be different given the month of the day?
AT&T could have added or subtracted cell sites in the area, which would change tower density. They could also reconfigure those cell sites so maybe they point different directions. Given the rural area, 2 or 3 months, I don't think you're going to see much of a change, but it's always possible. So if we're talking about recreating this exhibit exactly the way it was, we would need not just the regional tower list, we would need to know which version of the regional tower list to be used.
Is that generally why people in your field say their work?
We're talking best practices 101. We're creating a work product that is going to be used in a forensic nature, not showing how an extraction is done, not showing the source data that I use to create an exhibit. It happens, but for the most part, it's unheard of, especially somebody who is a subject matter expert in digital forensics. I won't say I haven't seen it, but it is rare.
Thank you. Let's move on and talk about the CAST draft report. Have you?
I'm sorry, Ms. Taylor, the CAST report.
Draft. Have
Can
you?
I ask how much longer on this? Because we're 90 minutes. I need to give the court reporter a break. But if you're going to finish, in 5 or 10 minutes, that's probably fine.
Your Honor, I would say we probably have 15 or 20 minutes or so. If the court wants to do a break, we can. Or
Yeah, let's take a recess. We'll be back in 10 minutes. Thank you. Relax.
All right. Power of watching it in replay. You can fast forward through breaks. It's
A
great.
tower list to make.
I hate commercials. I hate breaks. I love watching things in like fast mode because I need to retain faster. I can't. I don't know. It's my anxiety. I like it fast. And I don't like to stop and wait for things. So here we go.
Yeah, sorry. All right, good? Not on the record yet. Not on the record. Okay, we are back on record. This is State versus Koberger, CR 2922-2805. Everybody I identified previously are still here in the courtroom. Mr. Cy Ray is testifying. We are still on direct. Ms. Taylor, go ahead.
Thank you, Your Honor. Mr. Ray, when we left off at our break, I was about to talk to you about the CAST draft report. Okay, so we'll start there. Have you reviewed a CAST draft report in Mr. Koberger's case?
I have.
And From your review of that report, can you tell what records were relied on by Agent Balance to create that report?
That report would include, he had to have the AT&T CRs, the full 6 months, a tower list to make some conversions that I'm seeing on the report, and also drive test data, which would be another form of source data, and then a mapping platform to ingest the drive test data into, to analyze it, to create these shapes that are then put into the draft report.
Okay, I think I have that. Do we have the same call detail records that Nick Balance used to create his draft report?
Yes, well, I believe so.
Do those records appear to come from the December 23rd, 2022 to AT&T warrants?
I would say primarily the second warrant from what I reviewed.
And is that because the CAST draft report spans the full 6 months of those records?
That is correct.
Okay, and those records, did those come from the second AT&T search warrant?
That is also correct.
Can you tell anything about the tower report or how the tower information was used by Agent Nick Balance?
The tower identifiers that are predominantly used, not exclusively, but predominantly used in the CAST draft report did not come from the report AU. There's a conversion that can be made, and someone would have to have the national AT&T tower list, or at least the regional list. And I would take information from the CDRs. I would look at certain columns in this AT&T tower list, and I could get certain identifiers that are now being populated to the CAST report, if that makes sense.
Do we have a copy of the tower list that you believe was used?
We recently received 4 different versions. And when I say versions, they're just by month. And I believe we have August, September, November, and maybe December, maybe it's in October after that. So far, I've only had time to look at the November. And from what I can tell, all of that appears to be accurate.
Would we need the October or the missing month to be able to do our work accurately?
It's a really good practice. I'm sure that's why the FBI included it. If I'm mapping records over a long period of time, like in this case, 6 months, I do want to see the different versions of the tower list to make sure that if a change was made within the network during that 6-month period, the tower I map in July may map differently in November. So it is important to have that data.
This is why it's so important that you have all the little pieces of the investigation provided so that experts like this can go in and dig into the information and see, did they do things correctly? Did they not? But because they're not getting the work, the process, they're just getting the conclusion from law enforcement or from the prosecution. They're not getting the actual work to how they got to the conclusion to get to Brian Koberger, which is the problem. You need to show your work. It's like math. You know, every math class you ever had in school and you hated it, your teacher was like, show the work. How did you do that? And you can't just go, well, it just happens to be that way. You have to explain it. So that should be the case when someone's life is on the line also. Not just, oh, just believe us.
We have 4 of 6 months, but not the other 2.
Correct. It would be helpful to even maybe see May, because there may not have been an update made in late June, early July. So May's would be what I would start with.
Can you tell if drive testing was done to create that CAST draft report?
Yes, there's images in the latter part of the report of around slides 100 and above. I believe there's a total of 4 images that were populated to that report that would require drive testing.
When somebody's doing drive testing, do you expect data to be produced?
Absolutely. Creating a work product that uses drive testing and then coming into court and testifying without the drive testing is no different than creating an exhibit like this and then saying, well, we don't have to produce the AT&T records that created this. The source data for drive testing is the drive test.
Do we have the drive testing that was done by the FBI to help create that report?
We have what I believe is the majority. There are some significant pieces missing. I can't say that those missing pieces exist and haven't been turned over, or they were erroneously not collected. I don't know which, but there are some pretty significant pieces that are missing.
I'm going to ask you some questions about that. But first, I want to know when you first saw drive testing data that was produced to us in Discovery. What did that cover?
I found a file in the Discovery, I want to say early December, that included drive test, but it was about a 3-minute sample that covered less than a quarter of a mile in a completely irrelevant location. So it added no value to my analysis at all.
What were you looking for? What time frame and location were you looking for based on the CAST draft report review?
I would expect significant drive testing around any location that coverage maps were being used in the CAST report. I would expect significant documentation on potential routes that this device may have taken. I would expect significant documentation on privacy.
You just told us that you think we have most of it, but there's some significant parts that are missing.
Yeah, and I want to qualify that just so it's really clear because I understand it's starting to get very technical. There's over 500,000 lines of data that was turned over. So I'll make it clear there's a lot of data that has been produced. I would say, in my opinion, looking at what's been produced, probably 2 or 3% is missing, but it's not the amount of data or the time of the data, it's the locations of the data. Some of the most significant locations in this case, we're missing some data.
Those significant locations, have they been depicted or captured on the CAS draft report?
They have.
And tell me what those locations are. What are we missing?
I am unable to find any measurements along, I believe it's 270, the Moscow-Pullman Road. If you drove the most direct route from Pullman to Moscow or vice versa, pretty much as soon as you're leaving Pullman to the time that you arrive in Moscow, we are missing that entire stretch. If there's ever been a case that we need to look at, what does it look like when a phone travels from Pullman to Moscow? This is probably the case. We have the neighborhood around the crime scene, but we don't have the crime scene. Normally, that wouldn't be too terribly significant because if it's a flat area, there's not a lot of vegetation or mountains, you could probably interpret the same. The location of this crime scene is very unique because it sits on a mountain, part is shielded by a mountain. There's a lot of other big, thick, dense apartment buildings there. Your phone is going to behave differently inside of that residence than it might on the road behind the residence or in front of the residence. I can't find any drive test data that actually encapsulates any part of the property.
Wow.
You talked about the device that helps do the drive testing or that captures the data when you're doing the drive testing. What's that called?
It's a drive test scanner. The most common one used in law enforcement is created by Road and Schwartz. That's the same company I referred to earlier. I'm familiar with the hardware that the FBI uses, and it is a Road and Schwartz scanner.
Is it called Gladiator?
Gladiator is the company that sells the product to the FBI. Gladiator actually buys this product from Road and Schwartz, and it does what they call white labeling. So they buy the hardware from Road and Schwartz, and they kind of slap their sticker on it, and they put their software in it, and then they sell it to the FBI. But ultimately, it is a Road and Schwartz piece of hardware.
And once you have that piece of hardware, once you have this device, does it just work forever, or is there anything that has to be done to make sure it's working properly?
It is a technical piece of equipment that takes measurements. It is required to be calibrated. The best way that for probably everybody in the courtroom to think of, if we go a little old school, is the old breath test. If you had a DUI and law enforcement couldn't produce the calibration records of the breath test, it was really problematic. Similar thing here. We want to see that the device is calibrated. In this case, it's really important because, keep in mind, I reviewed thousands of these drive tests over my career. There is a significant gap that I believe there's something malfunctioning in the equipment, or the operators are just not paying attention. I can't tell you which one it is. So in this case, the calibration records to show that that device is functioning properly are really critical.
Do we have those calibration records on the device that was there more than one device used?
There's actually 2 devices used.
And was this drive test done on just one day? Is this a one-time shot?
No, I think there's maybe 5 days total that I've seen drive test data collected.
Okay. So now let's talk about the calibration for this instrument or this machine. Did we get records for all the machines that were used by the FBI in this case?
We got the calibration records that were taken prior to the use of these the samples. It'd be really helpful to have the calibration records after the use. So we kind of need to bookend those because we know that it left Road Schwartz factory in October and everything was working great. When it came back, we don't know when it came back, and we don't know if it was functioning properly when it came back. It's not uncommon for there to be errors. If I saw a report and said it came in and it had 2 errors, it's not the end of the world. The sky doesn't fall. You have to get into the documentation to see what those errors were. Normally, the device kind of self-calibrates itself. If you know what you're looking at, the major concerns that you would see, the calibration is off. It becomes very obvious because the results are really flawed. That's where I have a concern in this case is we have what I consider a significant chunk of data for specifically a location where the instrument is running. There's no doubt it's functioning, but it's not properly collecting AT&T data, which is concerning as to why.
Mm-hmm.
Because there were multiple drive tests done, and you talked about bookending these calibration reports, would you need to bookend all of the time that the drive testing was done with these calibration reports? And what I'm saying is if there's something done in November and then drive testing done in December and then more drive testing done in January and then maybe some in March, do you need the bookend calibration reports around each of those drive tests?
You would. To date, I haven't seen any drive test data, I believe, beyond January 5th. And I'm not sure the time zone, so maybe it could creep into January 6th. But if there's any drive test data after the first week of January, I'm unaware.
Okay. So in our case, which months are we missing?
For the calibration?
Yes.
Whatever the next calibration, the FBI would choose when to send these devices in. So whenever that next calibration report was generated for these 2 devices.
On the calibration certificates we have, I think you told us that after the maintenance, it went back into service and passed inspection was functioning properly.
Well, when it came in, it didn't have multiple errors, but when it went out, it was functioning properly.
Is that why you need to see the next one on the other side of the drive testing?
That is correct.
Okay. Now, when we're thinking about the drive test data that we have that's missing some significant portions, could it be because the machine wasn't working right all the time they tried to do drive testing?
Yes.
Okay. Is it also possible that the FBI agents using this machine weren't properly trained to do the drive test data or to do the drive testing and collect data?
I know of the two FBI agents from prior lives. I believe they're properly trained.
So we're looking at either the machine itself isn't functioning properly, or could that data have been pulled out of what we got?
If we're talking about possible scenarios that would cause the shortcoming of data, maybe it was never captured in the first place. I can't speak to that. The machine erring, at least during one portion of this drive test, I've seen similar errors before. I'm pretty sure they had a small period of time where it had been a very busy day and it kind of gave up for a little while, like any computer will, and needed to be reset. Could things be extracted and us not know? That's always possible. I can't rule that out.
Is the missing data important to you to fulfill your duties in Mr. Koberger's case?
I don't recall when I got involved in this case on the day where I could actually start looking at evidence. I've had a concern since the very first day I saw the CAS draft report that there are significant errors in the drive testing. It was before I even saw the drive testing. I can look at the coverage areas and I can tell you they're wrong. So yes, it's not a concern that they're wrong. People make mistakes. We can fix things. It's a concern that I still don't have the source data that any expert, not just myself, but anybody could sit down and look at and say, okay, I see what's happening here. Here's how we fix this. Unfortunately, that mistake has a ripple effect, and I'm seeing multiple errors that are happening as a result. So that's why this data is important, is we've reached a point that we need to determine, is this just human error? Is this accidental? Is it intentional? Is there other things at play here that's changing this narrative to where there's clearly some manipulation of the original data?
And having that data, will that help us answer that question?
It's the only way we're going to answer that question.
All right, I have just a couple of other questions for you, and I'm going to depart the CAS report and the drive test data a little bit, except as an investigator or as a person doing an analysis of this case, did the drive test data tell you where a phone traveled to indicate other investigation that you should do?
Technically, the call detail records tell us that. The drive test data help us become more accurate with that. AT&T is one of the best companies in this particular situation to show device movement because we get a constant connection. So when, and I will emphasize, when all of the data is mapped, and I'm talking about the CDRs, we can get a really good idea. Hey, a phone traveled north for 10 miles and then it traveled east. The drive test data would actually allow us to replicate and recreate these tower handoffs that we're seeing to come up with that first theory. To now we can say, in order to do this and hit these towers in the sequence that it did, it has to be driving on this highway. And then when it went east, it most likely turned onto this highway. So the drive test data helps us get very specific with what the CDRs mean.
As an investigator and performing an analysis work done in this case, when you have the CDRs, the call detail records that tell you where a phone's been, is that useful in directing your investigation to what other evidence might be out there, like videotapes?
I have to qualify my answer to it because I'm not sure if you're asking specifically for this case or in general. Yes, you map all of the data. And especially if you're going to justify 6 months worth of data on somebody's cell phone, you map every single connection that there is in those records. From what I have reviewed, the FBI mapped 6% of the data that came in. Mallory's testimony and what I've seen through here, he was up to about 18%. So by either standard, more than 80% on both accounts were never mapped or accounted for. And I'm not talking overall from every single day for 6 months. I'm talking about the timeframes that are chosen. So for example, this time period that's represented here is where I'm getting the 18%.
And that's the 48 hours?
This is specifically from 2 a.m. to 6 a.m. on the morning of the 13th, arguably the most critical time period of this entire investigation. They mapped a handful of connections. When I say handful, they mapped 18%. When you add the other 82%, it tells a much more detailed story. When we put the drive test data on top of that, you can get even more refined. But to answer your question on any case, that's this case. On any case, and we teach best practice, we've established best practices going back to 2008 in law enforcement of what you do with this type of data. It is a terrible practice to justify probable cause for this very detailed call detail records that give breadcrumb-like trails for individuals and then not map it. We justify an entire probable cause statement saying we have to have this. Not mapping it and then making decisions and work products with leaving that out is extremely problematic.
Yeah.
Last week, we received some additional records that Detective Mallory found when he was preparing for his testimony on this mission to compel. Have you had a chance to review those records?
I have. A couple of them are very technical, so I'm not going to say that I've mastered them yet, but I have a good idea of what was provided and what it means.
Based on your, I guess not as thorough as you'll do, review of these records, do you have a sense as to whether these records matter to us and what we're doing to defend Mr. Koberger?
Given the timing of these records, from what I can tell in the emails that were produced by Detective Mallory, these records were generated on the 23rd of December. It's when everything starts with probable cause statements. If I had to pick a time when the wheels fell off the wagon, that's the date. There are statements and there's assumptions made in the records that will never be supported by the data. There's a lot of claims that are said in these emails, and even the name files of the records are problematic. It does not represent what it's claimed to represent.
Sounds like those might be pretty important to us defending Mr. Koberger.
I could give examples, but I know it's a very technical thing, so I'm not it could be extremely impactful to either side. I'm not saying just in defending Mr. Koberger. It could be extremely impactful in prosecuting Mr. Koberger. The problem's the problem, not what the data helps or hurts.
The content of the data, though, is it helpful to us in representing Mr. Koberger?
It absolutely is helpful. Everything that I've seen to date is concerning to me because it's exculpatory. And I need to clarify this. When all of the records are produced and the dust settles and I have time to review it, I reserve the right to say, no, now I'm seeing everything. Here's what I'm seeing. Because of the piecemealing of the data, because of the missing data, because of data that I'm reviewing that is incredibly inaccurate, everything that is missing is absolutely in the benefit of the defense right now. There's other reports that I believe are missing that I can't tell you are in the benefit of Mr. Koberger or in the benefit of the state. If I was contacted on December 1st by Moscow Police Department, there are things I would have absolutely said, you get this today. Do not hesitate, and especially come December 23rd. Not because of who it's helpful for, but because those documents are the only things we're going to get that's going to be able to allow us to interpret what it really means. When we don't get those documents and we piecemeal things, it creates this narrative that is very harmful for the defense's case. As I've got more documents, I'm finding it's not harmful for the defense's case. There's a lot of misstatements that have been made. So yes, to your question, to date, it is very helpful for Mr. Koberger. I reserve the right to change that opinion in 6 months, depending on what type of documents are released and what's out there.
Fair enough. I need just a minute, but I don't think I have any other questions.
Thank you.
That's pretty crazy. But it makes sense.
Mr. Ray, thank you. I don't have any other questions right now, but hold on. The prosecutor might.
All right. Ms. Taylor, thanks.
No, no, I don't have any questions this time.
All right. Maybe
They didn't have any questions? Holy crap. No, he asked Miss Taylor. Let's see if the prosecution has any questions. But isn't it crazy? So it's like putting together a puzzle. You only have a certain number of pieces. It's not a complete picture. It's not complete unless you have a full, and until you start putting all the pieces together with a guy like this who knows what he's doing, you're not going to have enough of a clear picture. You can manipulate your picture by only using certain pieces to make it look like the defendant is guilty in this case. That's what he's saying. Like law enforcement, if you are just doing a 3% of his data from that night, you're not going to get a clear picture of where he was. But if you start to map all of it and where he was during what times, when you can see like this app opened when he was over here and this app pulled data when he was over here. So that's when you can start to really get a picture and a sense of where he was that night versus well, you heard Payne's, well, it was a combination of blah 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 blah. But he was using information that he didn't even know he had. He had tons of video that was collected in the case and he didn't even know where it was. So it doesn't give me a whole lot of confidence in the lead investigator. Anyways, let's continue.
so it's the excuse.
He may, Your Honor. Thank you.
All right, Mr. Ray, you're free to stay. You're free to leave if you like. Sure. Thank you.
He's free to go. No questions from the prosecution.
No witness.
Your Honor, we do not have any other witnesses and we have argument for the court.
Okay. Let's go ahead then.
Your Honor, what I'd like to do is I'd like to start with Ms. Nassa. She's going to cover one of the requests specific to the grand jury subpoenas, and then I'll cover the rest of this morning's argument.
Okay, thank you.
Your Honor, to facilitate this argument on this point, I am going to hand you defense exhibits A and B that were submitted in our records for today. I want you to be able to look at them while I'm talking.
Okay, thank you.
As of today, there have been at least 50 federal grand jury subpoenas that have been issued in this case. Exhibits A and Exhibits B are an example of copies of grand jury subpoenas that we have received out of those more than 50. And what I didn't provide to you that goes behind that what we got with those is the subpoenas include attachment A, which explains what is being subpoenaed. And then what has been produced is the responses to those subpoenas. And in some of the subpoenas, we also have the certification by the person who has produced the records in response to the subpoena. Some of them are missing. We have asked the state to produce all of the subpoenas. And their response is that they are not in possession and control of those subpoenas, and they do not intend to use the subpoenas as an exhibit And we have not justified why we need those subpoenas. And for those reasons, they are not going to produce them. I'd like to begin by saying that as it relates to any argument that the state is not in possession and control, rather than beat the dead horse on that issue, Idaho Supreme Court came down in 2023 and made it crystal clear that anybody that's acting on behalf of as an agent of the state puts those records in the hands of the state, and they need to produce them. State versus Pendleton, 2003. The other thing is that in terms of the state arguing that they are not going to use a subpoena as an exhibit, that is not in and of itself a defense to not produce a document to us. We have a million reasons why we need to look at documents. We understand that out of the 51 terabytes that have been produced, that not all of that is evidence that's going to be coming before the court or the jury, but it doesn't mean that they aren't material or exculpatory. The subpoenas, based on reviewing the records, are in the hands of basically three agents. There is an FBI forensic agent by the name of forensic accountant, Michael Douglas. There's a special agent, Travis Shirley, and there is another agent, Mary Tyndall. These are the three agents that are receiving the subpoenas, reaching out to the providers that they're serving and asking for the documents. For the court to understand why we need these documents, I want to tell you what we're doing with discovery and timelines. There are more than 100 search warrants in this case. There are more than 50 grand jury subpoenas in this case. You've heard all kinds of information about the probable cause affidavit and the timing of that. Timing in this case for the defense is everything. So we are creating timelines that put in the dates of affidavits of warrants, the information that's received, and the date that it's produced. With subpoenas, when we don't get a copy of the subpoena and all we get is the warrant or is the subpoena return, we don't know the scope of what the state has asked for. We don't know the date that the subpoena was served. And in some of them, we don't know that there is a certified return. So we can't take our timeline on warrants and our timeline on the probable cause affidavit and our timeline on everything else that we're putting in there and interlay the subpoena information that the state is getting. And we are desperate to find out the timeline in this case and when the state knew what and when. Mm-hmm. There's no question that motions to suppress are coming. Motions to suppress are coming on warrants. And whether or not those motions to suppress are based on Frank's material because misrepresentations are made depends on the timeline. So if there's a representation made in a warrant that things happen.
They want a Frank's hearing potentially, kind of like Delphi, basically showing that there was some potentially misrepresentations or misconduct or something along those lines by law enforcement, and their investigation is a little shoddy. So I look forward to reading any Frank's memos that they put forth if there are some motions to suppress warrants and things like that. I look forward to reading those. I think that'll be interesting. It'll give us a little more insight into this investigation since they've kept everything under seal.
In a certain way, if we are able to look at the timeline and say, we know that the state knew this when, that gives us an answer on whether or not the suppression issue includes a truthful statement in the affidavit. And if I'm not making sense, I want you to tell me to clarify that. But we need to know the timeline of all of the evidence in this case and when the state knew what it knew, or why certain things were being looked at before Mr. Koberger's arrest or well into late in the year in 2023 related to the victims, and try to piece together, is that something that the state is still seeking because they're pursuing the alternate suspects that exist in this case? There's so many things that we're trying to understand. So what we're asking you to do is enter an order compelling them to produce the subpoenas. You see that they had at least two in their possession that they possess, and it will clarify it for us. And we will be able to create our timeline and put all of these things together and know when and why the state was doing these things. And just to add one other component, you're hearing about cell phone records and cell phone records today being produced on warrants. Well, there were several sets of cell phone records that were produced pursuant to a grand jury subpoena. Still not clear to us why warrant versus subpoena, and they're different providers. And some of it's for phone numbers that we have to figure out who those phone numbers are. But all of this information is critical and material for us to be able to do the case, to do our work in this case. So I would ask that you enter an order to compel. And that way the state has the ability to take that to the FBI agents and say, the court has entered an order, we've got to produce the subpoenas, and we'll get the subpoenas. And to the extent that the state may stand up and say, we've got this 2E demands, we've got to deal with 2E. I just want to make it really clear for the court that 2E is not an obstacle. 2E is a hoop to jump through. The code related to 28 CFR 16.21, specifically states that the purpose of TUI is not to prevent federal agents from giving states discovery in a criminal case. Purpose of TUI is because these federal departments want to know when certain records are leaving their files. Understandable, but it's not meant to keep us from getting records that we need in this case.
Thank you. Response?
Well, simply put, we can't give over what we don't have. And we do not have the majority of these.
This is their answer every time. Go get it. Get it. Obtain it if you don't have it. You should have it. You're putting someone away for life. You're trying to end their life for this crime. So go get the information if you don't have it. That's the issue, lady. Sorry, this makes me mad. Well, we can't turn over what we don't have. You're just playing prosecutorial games here.
Subpoenas. What we do have, we've turned over. I reached out to the U.S. Attorney's Office. They advised they're not going to provide.
What? Why?
Because they don't provide subpoenas. You know, just like most grand jury material, it's sealed and not typically provided.
Not typically.
Not provided.
But even with a TUI letter, that wouldn't give it. We provide. They wouldn't follow that.
We have not. I'm not sure. But beyond that, though,
Try it then. Let's get it. Let's try every possible way to get it. Because it's not that the FBI told you they're not going to, it's that you haven't even tried. You have not tried. You have some measures you can take. You can file whatever the TUI motion is and get it to get the federal documents. That's what Karen Reed did in her case to get well, the feds turned it over voluntarily, but you can request it from a federal organization if you're in the middle of a litigation and you need information from the FBI, you can request it. And I don't know why they haven't done so, the prosecution. It's not that hard.
even if they were to provide it, I still don't understand how this moves the needle one way or the other. You can tell I've detailed there's 71 federal grand jury subpoenas. And in my response, I've detailed exactly what they were for and what records were received so that you can get the scope of what was requested from the actual records. The piece of paper that was given over saying, give us these records is all they're asking for, but they have the records. They have the important part of this.
So they have the timing based on the subpoenas
Off of
that
the
you
records,
provided to the defense.
off of the records provided. You can tell the scope as well as what they're for. And I've detailed exactly what they were for, the scope, in my response.
This isn't giving them
Okay,
the
response?
timeline.
Judge, I wouldn't be wasting the court's time asking for this if the questions were answered based on the state's response to our request for discovery.
Right.
Timing is critical on when a subpoena is served, what was the scope, then we can look at the documents to see if they're actually responsive to the scope. And knowing the timing of when that was served versus when it's produced to us is different. And again, I mentioned some of these things are pre-arrest of Mr. Koberger, and some of it is in the middle, and some of it is, frankly, months after the fact, if not a year after the fact, where they're looking for things related to the victims.
So
And
can I ask a question? Because Ms. Jennings just said that that the dates, well, all the subpoenas that were provided to you, 71 subpoenas, and each one of those had the scope of what the request was in the subpoena, and that it would be dated. No?
that's not true.
That's
That's not true. No. There are all kinds of different records and different methods that
And she didn't say that they were dated. She said just that they provided the data. She didn't say that they were dated.
the people that were the businesses and the people that were asked to produce the records produce them in different form. I do not know when they received the subpoena, the timing of it. And I do not know for all of these, what was the scope of what was asked for versus what was produced. I do know what's produced, but I don't know the timing. And the answer of the date discovery provided, which is in Exhibit 1, that the date that a discovery is provided to us doesn't answer the first two questions that I have, which is the timing of when they asked for it and the scope that was stated in the subpoena of what they asked for. Some companies were asked probably for a certain number of months, and they didn't have records that were responsive to those number of months, right? Because when the state's doing this investigation, they're not necessarily knowing exactly what records exist. So being able to be specific is important. And I want to touch on this issue of it. It's not in their possession. I get that. You have complete control over what evidence is going to be coming into this case with your orders. You make it crystal clear, produce it, or it's not coming in. That's the first level of sanction. And then we can just get going from there. You know, something that's destroyed, if you can't produce that, there's going to be a spoliation instruction. Something that we keep repeatedly asking for and it gets past time, we're going to knock the death penalty off the table. You know, you have control to get these issues that we are struggling with fixed by saying, this is my order, produce it, or there's going to be a sanction.
You may be overestimating my power.
I think you're underestimating your power.
Well, I have a good sense of where my power starts and ends. So I don't know. I mean, there's so much discovery that has been shared. Are all of these 71 subpoenas, have they been provided to me at this point? Because I don't think I've seen them.
No, they went through a federal grand jury. So this, you know, we haven't seen anything in terms of grand jury testimony, transcripts. What I have surmised based on my federal practice, because I spent about 50% of my time in federal court, is that they've used a federal grand jury as an investigative tool because the FBI is partnering with them. That makes complete sense. These subpoenas are in the hands of the 3 agents that I gave you the names of. They haven't come through you. They're in the hands of the agents. And so it's a matter of them just gathering the records that those agents have in their possession and providing to us. You know, and it helps us create this timeline in a case where discovery is being given to us as if we're living in a snow globe and it's just swirling around us and we're constantly having to put it together. So, you know, you've asked us several times, what can I do to help you guys get your work done? This is one of those things. Let us see the subpoenas so we can overlay this in our timeline.
But you just want the subpoenas. You don't necessarily are going to get the response.
We have the responses. We have the records. But what the records don't tell us is what was in the subpoena. It's like a warrant return. What is a warrant based on? It's based on an affidavit.
So this is what you want, the paper that says this is what we want.
And the Exhibit A that's attached to that, which I didn't give you a copy of Exhibit A, but Exhibit A is attached to each one of those, and then it specifies to the company, you know, you're looking for phone numbers that are this, and this for these dates.
It doesn't have the date on that when it was served?
Those subpoenas tell us, we know when they are served because it comes back with a date on it. And then, and then the attachment A has the scope of what they've asked for. What we've gotten is the documents without, it's like not having the affidavit to the warrant return.
Okay. I think I understand that. And I'm going to go back to Ms. Jennings and just clarify. What have they been given already?
They have been given records in response to all 71 of those federal grand jury subpoenas.
Do they have dated on there? Because that's...
Many of them do. You can see that from the description of the contents that I provided to the court. I can't say that all of them do, but many of them do.
Well, that's very important, apparently, for the defense, as Ms. Mathis said, that timing is everything here. So I think that's what they're really after. That's one of the things they're after is just the time frame.
We can seek to inquire as to, because what I keep hearing is they need to know the date that these various companies received the subpoena. We can still inquire. It's provided on a lot of these, right. But on the ones we're missing, we can attempt to inquire and find out the date that it was served. And we can still do that without providing the piece of paper.
Well, besides the timing, what's the relevance to this this scope that was requested? Yeah. You know,
what's the relevance?
Yeah.
We're not relying on any of this.
I know. I don't think you're. What do you think they think is relevant?
Yeah, for sure.
Okay. So what is the relevance? But aside with the timing, okay, and the scope.
Judge, I'm not going to give you the specific date right now in open court on one of the subpoenas, but they used a subpoena to get one of the most critical pieces of evidence in this case, and they know that.
Okay.
And they are going to use that.
It's something that I don't know about.
I mean, you probably you do know of it. It's in the probable cause affidavit.
Okay.
It's probably the DNA.
Thank you. All right, Ms. Jennings.
What I can tell you is that for the majority of the stuff, we did state search warrants, and we've received many of these records that way.
Okay, thank you. All right.
It's an important item, whatever it is, because she's like, they know that and they're going to use it. So obviously it's something that they are trying to connect Brian to the crime scene. So it probably is the knife sheath or the DNA or his DNA, getting his DNA from whatever 23andMe or whatever DNA genetic services he was using, because he had in the past. And that was a question as to whether he, the law enforcement went and took that back road into getting into the system and finding, like, if they went in as clients or whatever, as if they were a client, then they would get like more information on their genetics or whatever. So I think that subpoena, that might have something to do with what they're asking for, potentially.
Enough with that. Thank you very much. Appreciate it. Maybe it's a time to, well, let's see. Well, you still have your argument. How long do you think?
Your Honor, my intention is to talk about the law that governs discovery requests and ask you to compel certain things. I'm going to go through our fourth request. I'm going to tell you a few things that we have, and I'm going to tell you why you ought to order that the state give us the rest of it, how it's material to us, and how it's in the possession of control of the state. I'm going to do something. But I would say I'm going to talk 15 minutes, maybe.
Okay, great. Go ahead.
Thank you. Your Honor, then where I want to start is with Idaho Criminal Rule 16 that governs discovery. 16A directs which things are mandatory disclosures from the state. Those are things I don't even have to ask for. And those are items that the state has possession and control over that would tend to negate guilt or reduce punishment. 16B is the portion of the rule that governs when I request items in the course of my preparation of the case. And I would have the court keep in mind 16A and the prosecutor's responsibilities and Idaho Criminal Rule 16B and the discovery requests that we've made and what we have not received. We've asked for documents, we've asked for reports, we've asked for qualifications and summaries from experts, and we've asked for media that's been gathered in the case. The court can order other things that we asked for based on the need of the case. I would remind the court of the case that Ms. Massa just talked to the court about, State versus Pendleton. I know the court's familiar with this. This is a good case because it's recent and because it takes the time to define what's material and what's within the possession and control of the state. We need to think about our motion to compel in the order we are requesting from you in the context of what's in the possession and control of the state. Your Honor, the State versus Pendleton case says that any law enforcement, and this includes the prosecutor's office, it includes their staff, it includes any law enforcement that worked with them on the case. In this case, you're looking at Moscow Police Department, Idaho State Police Department, Idaho State Police Forensics Lab, and FBI agents, to name a few. So what those entities have and have developed are within the possession and control of the prosecutor. So with that backdrop, I want to run through our specific requests and talk about what we need. You've heard testimony, and so I think you know why these things are material, but let's go over it again. Starting with the fourth motion to compel. Ms. Massoff went over 1A, the grand jury subpoenas. I'm going to leave that argument alone. She did a fabulous job with that. When we're looking at 2A, this all comes from the defendant's 11th supplemental request for discovery. 2A is the video on King Street. Your Honor, we began asking for that a long time ago. We have it in full, so we don't have to talk about that. We received that full for all of the hours and days in question with both audio and video on 510. So we can mark 2A, item 219 off of our list.
219.
219.
I've gone through pages and pages and pages. So I think I really appreciate you being very specific about, what you have now and what you will still.
Okay, good, because it's the only way I can keep track of it.
Yeah, well, same here. Thank you.
You're welcome. Your Honor, item 2B in our fourth motion to compel is item 224. That's the cast biz log. And this one is rough. The court heard last week Detective Mowry say, I don't have any of those, except I found these other items that we'll give you now, which were not Mowry's past biz logs. The hard part for us about this one, Judge, and I have to make a record. I think you can order them to double check, and I'm going to ask you to order them to double check. But the hard part of this for me is that on January 9th, we asked for these cast biz logs. And the response from the state was cast biz does not produce logs. And that's just not true. It does. It's capable. It produces logs. You've heard that in the testimony. Then we filed our motion to compel and explained we have an expert, we know it produces logs, we're going to bring them. And the response was the working files were not saved. We received that response on April 23rd, 2024. And then on May 10th, we got a little bit more explanation about default settings were used and optional session files were not uploaded. This is really, really difficult because of the varying answers that we've received. The court's heard testimony from Mr. Ray about how important these logs are to know what was done.
It's very concerning. Very concerning. And it makes me feel like they don't want to turn it over for a reason.
This is really challenging. We can't recreate what Detective Mowry, who testified before the grand jury, did, unless the court orders that we get the tower list he used and we have the cast biz program. And quite frankly, that's what we want. We need to see how this work was done. This is important work. I'll tell you the other thing that's really troubling and frustrating, aside from the other files that we received in preparation for motion to compel, is these screenshots that we got for the first time last week when we're on a motion to compel and have a witness before the court. We didn't have those screenshots that Detective Mowry had created before. The only thing we had was Exhibit 48 that was given to the grand jury, which is a video that was handed over then. So this is really problematic to be told these varying things and then have something else produced on the day of testimony. Your Honor, we are going to request that the court order that we have the tower list used by Detective Mallory and access to the CAST-VIZ program so our expert, Mr. Cy Ray, can go through and see what Detective Mallory did.
Anything that law enforcement does in the process of investigation, defense should be able to come back and like try to recreate it or debunk it or whatever, because that's how you put on your defense. So you can't just tell me, well, this is my answer, but I'm not telling you how I got to the answer. Here's your answer. Here's Brian Koberger, and just take our word for it. What? It doesn't work that way. There's a reason why we have evidence rules and why we have discovery rules and why defendants are able to or should be able to look the accuser in the eye in an open court and be able to have legal representation to bring them through it. There's a reason why we do it this way, but let's just forget that and hide evidence. That's what I think is happening here.
That it's imperative that we be allowed to do that. That's the only way to recreate what Detective Mallory did.
It seems to me he did acknowledge that he just went back and provided this a day or 2 days before he testified that he found this additional information. So I'm thinking that the state got that information and had provided that to you. Now, we also heard a lot of the quotes missing pieces today, which I'm guessing that FBI, Mr. Valance and Detective Mallory are going to go back through that and see if there's something else. At this point, I'm assuming that some things may have fallen through the cracks. I mean, it is very complicated. There was a lot going on. We have some time before a trial. I just hope that everybody goes through their computers or their files or whatever they're going through so that it's complete. So what I've been watching over the last 2 months is that there have been supplemental responses to the defense. So things were coming in. They were waiting for information to come in so that they could provide that to you. So that's why I don't want to go backwards either. I just want to make sure that we are addressing what you don't have and what actually you're entitled to. So that's the tower list. I mean, I don't know anything about tower list, so I'm learning about that. I don't know that Detective Mallory addressed that, really, unless I missed that.
Your Honor, I believe he testified last week that he used the tower list that was contained in the AT&T record that he received. You heard today that doesn't exist. And you heard today that the tower list was something different that he used. And that tower list once that was entered, there was a selection on the program to do tower density as well. Like I said,
it's confusing.
It is. It definitely is.
We'll keep going.
Okay, thank you.
You want the tower list?
Yes, I think I'm getting there, but I definitely want that. I want the one that Mallory used to do his CAST-VIZ work back in May of last year. That's the one I really want right now, at least at this juncture in the documents right now. I do want to clear up, though, when we talk about what Detective Mallory found last week when he was preparing to testify, those are emails between him and Nick Valance. Those are JSON files from Nick Valance to Detective Mallory. None of those things that he found, other than screenshots, like the exhibit that you have of his map with the different sized towers depicted, other than those screenshots, the other things he had came from Nick Valance. Those were not his logs that he found. Those were not his towers that he found, just to be sure that those are still missing to the extent they exist. And we can't recreate what he did without the list and program. Moving on.
Thank you.
Moving on then, Your Honor, is item 226. That's called the Hemisphere Program, also known as a Timing Advanced Report. Your Honor, this is one of the troubling areas again. The first response was that the records do not exist. There were letters exchanged between the state and us asking for more information. In one of the letters from the prosecutor, we were told that this program was not used in Brian Koberger's case. And then we filed a motion to compel, and we were told that the state was not in possession of the timing records. And then the next supplemental response in May of this year, just a couple of weeks ago, was to tell us that there's some new certified records from AT&T that we're going to get. I don't know what those are. I can tell you that these timing advanced reports were asked for from AT&T, from Verizon, from T-Mobile, and another cell phone company in both of the early AT&T warrants. We called them the 48-hour and then the extended warrants back on December 23rd, 2022. We don't have those. So I just want to make a record that I need to know what happens.
Yeah.
Moving on then to 228, item 228. That was trying to understand what was relied upon for the second AT&T warrant. And we heard quite a bit today from Detective Payne about what he relied on for that second warrant. And that had to do with what was produced and analyzed in the first warrant. However, we asked for some emails and some communications. We know about some text messaging that we've received, but we don't have written correspondence, email correspondence, exchanging information, just the text messaging. So we want all of the email communication between Payne and Balance, well, between anybody from Moscow PD and anybody from the FBI. Your Honor, item 229 is the MAID data. I would say we received a disclosure, and I think we got that on either 510 or 517. And I'm going to need some time to have an expert help me out with that. I don't know if that's complete. I also know that in the fifth motion to compel, there is information we've asked for from Babel. That was a program that was used to help decipher some of the MAID data. And we're going to talk about that in a minute, but that one's yet to come. So I'm going to ask the court for an order compelling the state to give me all the MAID data. They may have already complied. So their intent to comply, I can tell you that.
What does that stand for again?
Mobile advertiser. Let's see, I've got it in here.
Okay. I'm glad.
Identification number, mobile advertiser identification number.
Okay, thank you.
You're welcome. All right, Judge, we are now talking about item 242, the CAST report. The history of this is we came to the court asking for the CAST report, knowing it was relied upon last year, and the court ordered that we receive it. We received one that was stamped draft all over it. You've heard testimony about that today from Mr. Ray. And it's not a final report. And we knew that when we got it. We asked for that. We asked for the analysis behind that. And we haven't received that. We were told on February 23rd of this year that the state will provide this by March 31st. Well, March 31st came and went, and we did not get it. So on April 23rd, the state said we still don't have it. And then on May the 10th, the state responded to this request and said that because we provided additional information, Mr. Koberger's alibi, they need more time to do work on this CAST report, and they'll get it to us later.
What?
Your Honor, I think you ought to order that we get the CAST report, and I think you ought to order that we get everything that went into developing this, and we get the analysis that they made from that.
Yeah.
This is particularly troubling. Their response, you told us something, so now we have to go reconfigure the CAST report. Let me tell you why that's troubling. Item 243 is our request. Give us a list of everything Nick Balance relied on when drafting his CAST report. And we were told Nick Balance relied on the call detail records from AT&T. Nick Balance relied upon tower records, and he relied upon the drive test data. Nowhere in there does it say, if you tell us anything about the case, we need that to rely on that too. These are records that exist. These are tower lists that exist. They go into a program. You do drive tests.
Yeah, they're records that exist independently of an alibi.
To understand how the device interacts with towers, and you create a report. So we're asking the court to order that we get the CAST draft report, we get the full list of everything he relied upon, and we get the analysis of what does this mean.
So another clarifying question, maybe. So I listened to the testimony today, and that it sounded like a CAST report was provided, but maybe it wasn't complete, is what Mr. Ray suggested. But I think that I'm guessing they're assuming that the state provided what they had, but it maybe they're still working on it. I don't know. But didn't you get initially what they had as they characterized as the CAST report? So when you say, I mean, we have problems with language, I think, especially when we're in this area of technology. And so we might be just going back and forth like this without really understanding what we're asking for or what we're providing.
No.
Let me see if I can clear that up. The testimony today, when we had Detective Payne on the stand, when we talked about what did you rely on to get the second AT&T warrant, he said that there was something that Nick Balance produced and that the prosecutor had it, and he thought it was a CAST draft. And then you heard from Mr. Ray, who said, I've seen a CAST draft report, and maybe it's something different that Detective Payne looked at. It wasn't this big, long CAST draft. The CAST draft report, and I'm calling it draft because it's stamped draft. I knew it wasn't final when I received it. We got that because you ordered that the state give that to us last July. So I had this draft. I knew it wasn't final. Ms. Jennings knew it wasn't final. We've talked about it. We believed that we were going to get the final report by March 31st. We don't have that yet. It's the final report that we need. You also heard from Mr. Ray talking about the things that are mistakes in the CAST draft report. These reports go through a peer review process and they can look a little different when they come back out on the other side. Usually not vastly different, but they can. They go through their process. It's that final product that I need that. I need to know everything they relied on to do their work. I need to know what this draft report is going to look like. The court should know that when we get to trial, likely Agent Balance is going to come in and talk about his cast draft report. He's going to be an expert in the field and talk about what he found and why he found and what he relied on to do that. I'm going to come in with an expert that's going to explain what his work did. Now, if the work aligns and Nicholas Balance and our expert aligns, well, that's just going to be shorter. But right now, it's definitely not looking like that. It looks like they're going to have their side, and we're going to be talking about what the data shows. So what I want is the final report that we were told would be available by March 31st.
That was like a total dig. They're gonna be saying what they say, and we're gonna tell the truth. That's what you just said,
I need time to work on it.
basically.
Sure.
What I want is a full list of what was used to create that report, what was relied on. I have to be able to see if I can recreate that. I have to see what was right with it and what was wrong with it. So I don't have those two things, right?
Is it possible that it's just not completed?
It is
It's
possible.
a final report?
It is possible, but I need you to order that come to me. And I don't think Ms. Jennings doesn't want to give it to me. But if you order that I get it, then I'm going to get it a lot sooner, I think. I'm not saying that Ms. Jennings is sitting holding it behind her back. I'm saying I don't now know what's going on. The FBI told her it was going to be in by March 31st. We hit our deadline to disclose our alibi. And all of a sudden now they need to redo something in the report, which shocks me because of the things they said that they relied on were things that already existed. So now I really need to know what they're relying on to do this report. And I really need to see the analysis and I really need to see the final report.
Sure.
I have to react to it.
Since we're talking about this, Ms. Jennings, do you want to just respond to that? Whether or not this is still a work in progress or what's going on?
Right, Your Honor. As I know right now, that report is not in its final form, and it has gone through a peer review process. My understanding is it's still in that. I have been told that yes, it's not a matter of redoing anything, but as they receive additional information, they just want to double check their work. They want to make sure that when they get the final report, it's accurate. So we are still waiting for that final report to ensure that it's accurate. And as soon as we receive it,
I'm sorry. You have a time frame for that? I told you when they expect to be finished?
I don't have a final time frame. They originally told us it was projected to be completed by June next month. So I'm hoping to get it within the next month.
All right, thank you. Appreciate that. Sometimes it's easier just to sort a particular issue at the same time.
So the hot ones, it might be, Your Honor.
Yes.
Your Honor, I do think we have the regional tower list now, so I think we're good with that. On item number 244 and 245, we have those documents now, so we're good there. Moving then to item 248. This is the drive test data, the mapping data. The court heard pretty extensively that we've received this in two places. We received some early on, and then we received a lot more recently, but it appears to still be missing some. Asking the court just to order that we receive the entirety of all drive test data that was conducted by Agent Balance or anybody from the FBI. 249 is anything that exists after January 6th of 2023 for the drive test data. That's number 249. And so it would ask the court to order that to the extent that it exists. Would ask that it be ordered to be produced. Item 250 is the training and certification records for Nick Balance and Sean Kennedy relating specifically to the use of the Gladiator or the GAR. That's the item used to conduct these drive tests. Your Honor, I think that we gave the court a transcript of testimony of Nick Balance that occurred within the last year. And that transcript had highlighting on it, so the court didn't have to read the whole thing, but to look at how many times the training and experience was relied upon by this expert, and that expert's Nick Balance. And if he's going to be a testifying expert, the discovery rules allow for us to have their training. We asked for it specific to this Gladiator because we know that's going to be a big part of his testimony. So we're asking the court to order that we receive his training and certification records relating to the GAR product.
Yeah, that's important. You need to know how qualified he is in this. Is he an expert? You have to be able to find out based on, the fact that they are a law enforcement officer first, and then they do this data stuff, second. So, and you might want to make sure that their training is enough to say, yes, they are qualified and they're an expert in this field. A lot of times you would do that with like a voir dire where they would be questioned by an attorney in front of no jury or anything like that, but just so both sides can ask them questions and the judge can rule based on those answers.
Similarly, now we'll talk about the GAR unit itself and its calibration records or its certificates that it's in compliance. The court just heard the testimony from Mr. Ray about how important that is. That often they get tired, things go wrong with them, and they get restored to service. We do have 2 certificates, but what we need is what Mr. Ray called the bookend. So we need the other side. We know that it came in non-compliant and that it was restored and went back out. We don't know what happened after it was used, and we don't know the next bit of calibration that it went through. We don't know how it checked out. So we need the full copy, the bookend copy of the calibration reports.
This is still in 250.
That one is 250. Yes. Sorry, Judge, I think that might have been 251. That wasn't 251. 250 is the training records for the agents, and 251 is for the calibration records for the instrument. I apologize for that. 258 is a request for all information, all data, including all expert reports that the state has relied upon in developing the affidavits in support of all warrants.
That's like a big one.
It's a big one. And the state responded with an answer saying, these are the things that have been relied on. I'll tell you what my concern is, that there are things maybe in computer files, things on somebody's desk that haven't been turned over yet. So I think the court ought to order that the state make sure they've given us everything that was relied on for every single one of the warrants. Ms. Massa indicated to the court, and I know that other members, I think Mr. Logston has indicated that we're going to have motions to suppress. And so we want to make sure that we have all of the information. Possibly it would answer questions so we don't have to have quite as many, but
So we don't have to what?
have quite as many motions to suppress.
Okay, thank you.
That's not a problem.
I understand.
All right, Judge, let's talk about the 5th motion to compel. That completed the 4th. The 5th motion to compel, we are not going to talk about the 15th request for discovery until this afternoon. So my comments will relate to the supplemental request for discovery, number 12, number 13, and number 14.
12, 13, 14.
Yes. In request number 259, number 260, 261, 262, and 265, the state has let us know that these are coming. They responded on May 10th and said these are coming. They don't have a problem. So we're asking the court to order them to be disclosed to us. I think these are some that aren't going to be available for a while, but I think the court ought to order it. The state doesn't seem to have an objection to us having them. The order will mean we don't have to come back if something doesn't get through to us.
Okay, can you give me those numbers again, please?
Yes, I can. It's number 259, number 260, number 261, 262, and 265.
Thank you.
Your Honor, 289 related to communications between Detective Kane and the WSU officer talking about white elantras. I believe that that's been covered. Kane testified today that we have the instant messages and there was only a phone call and that was it. So to the extent that that's the very end of it, then we're fine. And so I think we are on that one. Item number 299 is called a TIPS lead sheet. And that's something that's referenced during the course of in the discovery. We were asked for an example that was sent to the state. I'm just going to ask the court to order that be disclosed to us. Number 300 relates to emails, notes, and other communications. The state's responded with 3 separate AV files, and I'm going to ask the court just to order that they all be given to us. We may have them all, but I'm going to ask that the court just order that just to be sure that we have them. Well, Your Honor, I take that back. I spoke with Ms. Jennings, and I know there's one area, I'm not going to talk about the area, but I know there's still one area that we don't have, so I'm going to ask the court to order that all emails, notes, and communications be produced to us. Your Honor, the next item is the CAST certification and training for Nick Valance, and for many of the same reasons that we asked for that for the Gladiator. We need to have his training records. He's going to come in as an expert. The discovery rules cover this. You can see an example of him testifying as an expert in the transcript that I provided.
That's not covered by 250.
250 is the training related to the Gladiator specifically. This one is relating very specifically to his training for his CAST work and certification for his CAST work.
I'm sorry. What was the number for that training?
I do not think
that 300.
That one's not 300. Let me find that one. I didn't write that number down. Give me 263. Don't have to save the day.
263.
And 264, I believe, relates to Sean Kennedy. Yeah, he's another FBI CAST person. And I am now at. Still.
There's a lot that they still have not turned over.
Your Honor, items 274, 275, and 278 have been provided. Item 287 relates to a new expert, a blood spatter expert that the state is working with. We're told that that's going to be available in June. It doesn't seem that there's an objection. We'd ask the court to order that to be provided to us once received by the state. Request 289 we have. We're now at the 13th supplemental request for discovery. And that one is 302, item 302. That's similar to several others. So I'm going to hold the argument on that for a minute. I'm going to let the court know that items 303, 304, 305 have been provided to us, except there's going to be some raw data provided to us. And to that extent, would ask the court order that we receive the raw data that have otherwise been complied with. Items 306, 309, and 308. The response from the state has been that we've now worked through the 2-week process. That letter's been given to the FBI, and so we may get those by early June. So we ask the court to order that those be produced. I don't think the state's objecting to those. They just don't quite have them yet. 307 has been provided. Your Honor, 313, those are the Department of Transportation cameras. We heard testimony about that last week, that there was a letter preserving still shots, but not any video was available. So I think that that's been complied with to the extent that it can be complied with. 314 was the email communication, and we received that, so that's been complied with. 316 and 315, I believe, are also subject to the 2-week letter, so we'd ask the court order those be provided as soon as they're received. And now moving on to request 317, 322, 319, 320, 321, 323, 320, and 324. And then picking back up with 302. Those are all surveillance camera items that we've requested. We're asking the court to order Moscow Police Department, as the custodian of these things in this case, to do an inventory of what's there. You heard last week that Detective Mallory said, I don't have the videos, those aren't my responsibility. You heard today Detective Payne said it's Mallory and FBI agents. So we take Mallory out of the equation. He says, I didn't do it. I can't tell you where these videos are. I don't know who the FBI agents are. So first, I think the court ought to order that be disclosed to me. The second offer was that I can go to the Moscow Police Department evidence room and go through hundreds of hours, thousands of hours of videotapes, and that's just not reasonable. These are videotapes that have been collected in the course of this investigation. You heard Detective Payne say that when he looked at cameras on South 95 and the other road south of Moscow on the date in question, and in conformance with what he alleged in his affidavit of probable cause to arrest Brian, he looked at those videos and he didn't find a car. That screams stuff that's exculpatory to me. I need to know where these videos are. They were collected. The court can see that from the reports that we put in the packet of evidence. The court knows they've been collected, but nobody can tell me where they are. And I need help. I don't physically have time to go watch thousands of hours in Moscow Police Department and be efficient with the case. But if that's what I have to do, I guess I need the court to tell me that's what I have to do. I think you have the ability to order that there be an accounting of all of these videos. Keep in mind what we heard today was exculpatory. So there has to be a duty to categorize all of these videos and get that information to me. Go find these videos that other police officers turned over to Moscow Police Department that are in relevant areas. That's just critical, and that needs to happen.
So I did look at a long list of videos that were provided to the defense that said there was nothing there, or the camera was broken, or so there was some kind of inventory there. And we saw that, right?
Yes.
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 Okay. So what you want now is just a complete inventory of all of the videos that they obtained.
That would be appropriate to have that, but there are specifically named videos in this fifth motion to compel that we specifically want the videos. We know they're there. We've read the police report.
Okay, and at least 317 through, 324, you're saying that those are specific
There's a
videos that you want, that you think are in this inventory.
Well, I don't know if they're in that inventory. I don't have them. I know they were collected and given to Moscow Police Department. I want to know where they are. And we listed out in 317, in 322, 319, 320, 321, 323, and 324 different locations that say we collected these. We gave them to Moscow Police Department. That's what I need to know. Where are they?
You didn't get any of these videos of this list that you just gave me.
No, of that list I gave you, I did not. There was also one that I asked to be included I'm coming back to that number. It's
302.
302. We did get a time frame on the day before the incident. And so I need to know where the time frame after the incident is.
Okay.
Okay.
Thank you.
Thank you, Judge, for that. I'm close to being done. Number 325. The answer was that if there was communications, it would have been a call. So that one's fine. We're good with that one. Number 326 is Uber logs between Detective Mallory and the Uber company. They've been provided to us, but I can't get into them. They're password protected. Miss Jennings and I have been trying to work that out. I think she'll continue to try to help me, but to the extent that it doesn't work, I'll need a copy that does work in some point. 336. 336 has to do with records, and I believe that Miss Jennings has provided or is providing a police report that will indicate these records don't exist based on an interview that was done. So we don't need to do anything with that one today. And I think the rest of them, 335, 336, 337, 338, and 339, the state has indicated that we've been given everything there is and nothing else exists. This all has to do with vehicle identification, and we're talking about identifying a car in question from a video as being a 2011 to 13 Elan truck. They say we have it all. So if we have it all, that's great. I just don't want any surprises. Again, Your Honor, and we think the court should order the things as we outline. They are material to the preparation of our defense. I would remind the court that relevance is a standard of whether it gets in front of the jury, but it's a different standard when we're talking about materiality. That was talked about in the Pendleton case, and I know the court's familiar with the Pendleton case. The court wrote about that in a previous order.
Yes.
So I'll leave it at that and just request that the court order these things so we can.
I'm at that list at the end about the identification of vehicle. You're saying that they have provided that to you, but they're telling you that's all they have.
Yes, there are specific items that they say, we gave you everything that's there. The rest of these items don't exist. It has to do with cameras and camera angles and different things like that. It's spelled out in the fifth motion to compel.
Okay.
I just don't want to be surprised.
You just want to make sure that if they find something else, they provide some supplemental response.
Well, I'd be concerned if they find something else after
Right.
they said nothing
Well,
else exists.
they're shaking their heads right now, but you never know. So, okay. Thank you very much.
Thank you, Judge.
Ms. Jennings,
Thank you, Judge.
it's a lot of stuff there.
Yes, and I'll try to make this quick. I'll kind of go through each of these items that are still out there for discussion. But just to give you a little bit of perspective of what all has been provided to date. The state has
Well, I rest assured, both sides, that I have gone through page after page after page after page. So, yeah, I understand. I have some perspective about what's been going on and how hard both sides have been working. So,
and just to give a little context why this isn't just so simple. To date, we've given 15,691 bait stamped pages of discovery. So for a little context, this is too much binder. It would be about 39 of these. We've given 13,758 bait stamped photographs. That's about 34 of those binders of photographs. We've given 911.
Giving a list of the amount of things that you've given doesn't help them because the things that you haven't turned over is still missing and they still need it. So going over and saying, well, we gave them all this, so why do they need this? That's apples and oranges. So stupid.
AV dumps. Those are digital files. In addition to a massive hard drive, about 50 terabytes full of discovery. And that includes audio, video from about 285 interviews, 15,000 video clips from approximately 79 businesses, 8,000 video clips from approximately 10 residences, 417 files containing call detail records, multiple terabytes of records for 11 computer devices, 17 cell phones, multiple social media accounts, and 4 tower dumps.
Excuse me, Ms. Jennings.
4 tower dumps. In addition to records regarding well over 17,000 tips. We've given multiple terabytes of records in response to the 71 grand jury subpoenas, as well as the 101 search warrants that were done in this case. We have facilitated the defense viewing the physical evidence on multiple occasions, as well as facilitated additional DNA trace evidence to be examined at their request. We've had a consistent pattern of loading up discovery and providing a hard drive to the defense on an almost weekly basis. And just to be clear, we're going to continue to do that. As we receive discovery, we review it, we load it on our hard drive, and we give it over. Now, going specifically through each of the requests, we've already dealt with in the 4th motion to compel. Item 214, we've already argued. Item 219, we've already complied with. the CAS viz logs. We heard the testimony, and what we know and what the judge heard testimony for is the CAS viz is just a software program that allows investigators to put in like the records received from a cell phone provider like AT&T into a software program and then kind of visualize. Detective Mallory testified he got the raw data set from AT&T, used the default settings for the times in question. It produced a map. He took a screenshot of that map. We provided that screenshot. He only did this in response to our request to provide a visual for the grand jury. We've been told that optional session files were not created or saved, and that this item simply doesn't exist. In the current version of CAS-Viz, the user settings aren't automatically saved in an exported session, but instead it just returns to default settings. I asked Detective Mallory about this. He advised us that he used the default settings. It doesn't take much time or effort to redo this, which is why he didn't save those logs. That's his normal practice. He just saved the screenshots and we provided that. We agree, we will double check. We're doing that throughout all of this. To our knowledge, there are not tower documents that were relied upon, but we will double check and inquire, and if that exists, then we will turn it over. 226 has to do, well, first the request was for the AT&T Hemisphere program, and then it detailed several other things below it. And we were told they didn't use the Hemisphere program. And you're right, language is important as to exactly what's being requested. And now after a series of back and forth, they're saying that they want AT&T timing report. We have been told if that's referring to timing advance records, those records don't exist. We do have these location records, the DVOR records, and we've given those over. Now, the second part, it says that investigators recently obtained certified records from AT&T, and that'll be disclosed in upcoming discovery production. My understanding is that that's not related to the above. It's not related to Brian Koberger's records. It's related to other records that were done later for other folks, but we will be providing that in the next production doc. Next is 228, complete copy of all materials relied upon Corporal Payne. To our knowledge, we've turned all of that over. We have given the documentation of correspondence between our CAST agent Balance as well as with Detective Payne. And he testified today that the only other communication, they were together. So they were just relaying things verbally, and that he was including that information in his report.
Can you give me the numbers too? Because I'm trying to keep track.
I am on 228.
Thank you.
229 has been complied with. Now we're at 242, a complete CAST report. We've already discussed that.
When you say complied with, does that mean that both sides agree that it was complied with? Or is it that you saying that you complied with that, but they are still asking for it? I just want to, speaking of language.
Well, I can't speak for the defense, but to our knowledge, we have provided everything that relates to the MAID data.
Okay. I just want to be clear about that. So if both sides agree that this is done, we don't need to keep arguing about this. But if the state is saying, well, we've complied, but they don't agree with that, then that's something I have to deal with. Ms. Taylor.
Your Honor, there's so much here. So the clarification on this is they did give us MAID data. I've been working with our expert and we think that all the data is there, but part 2 of it has to do with the Babel information that's coming. That's in the 5th motion to compel.
And that's a great
good one to remember. Yeah.
Yes.
And so I need that to put those two together. So I think the MAID data we have, I need to reserve though and say once our experts had full time to look at the MAID data, once we get the Babel stuff as well, then we may have a problem. But they did do a disclosure. For sure they did do a disclosure. I just can't say it's all of what we were looking for quite yet.
All right. So some of these we might come back to me to say, okay, where there's something missing or everything's fine.
And I will speak with Ms. Jensen if I notice that ahead of time too.
Okay, thank you.
243 relates to the final draft of the CAST report. 244 is done. 248, there's still some questions about. I will say that Ms. Taylor reached out to me last week, letting me know that they believe there might be some missing pieces there. I reached out to SA Balance, asking, he was at a training all last week. I've been told he's looking into it to see if there is additional information, then of course we would produce that. That's all I know at this point. 249 is related to the above. 250 to the state belief that's been done. And 258, again, this is a very broad request. If there's something specifically that they're looking for, that would be helpful. But as far as the state's concerned, we've complied with this request. We've given you the returns for all of the 101 search warrants that were done, as well as the affidavits, which detail exactly what the investigator relied upon in order to obtain those search warrants. Again, if there is something specific that they're seeking or looking for, if they can provide that to us, then we will inquire. Now we move on to the 5th. Items 259 through, 259, 260, 261, 262, and 265. Yes, our answer is that we have inquired. We've been told that this is coming. The employee responsible for these items is out on medical leave for about 6 to 8 weeks. We still have probably another month left before she returns, and then would need time for that to be completed. But we do intend on giving this over. As we've done already, as we get it, we turn it over. Item 289, this is completed. 299, temp lead sheets. State has provided information for well over 17,000 tips in this case. We've been advised by the FBI that they believe they have provided all information related to tips. Now, I'm unsure if there are duplicates of the same information. We will inquire, but substantively, it's our understanding that they have all the information for the 17,000 tips. But yes, I will inquire and see if there's something, a tip lead sheet that can be easily provided. 300. This has, for the majority, already been provided. They already have the ISP and PD emails. I've talked to Ms. Taylor about another certain section of emails that she would like to see. I will inquire about that, and if they exist, we will turn them over. 263 and 264 have to do with CAS certification and training records. I can tell the court we're going to comply with this. We're not at our expert discovery disclosure deadline, and we're just not at that point, but we will be. And we plan on giving this over on anything we intend to rely on. 274, 275, 278 have all been done. 287, this is an expert analysis. We haven't received it. We are expecting to receive it sometime in the next month. As soon as we receive that, we will discover. 289 is done. And starting with 302 is when we get into all these different surveillance videos. We have provided them a list of all the videos as they're labeled and as they're stored at MPD. Now, yes, we will do our due diligence to make sure that what we have is turned over. To date, though, and we'll continue to do that. To date, we have located a Watson Carey construction video, but the only thing we've located is one that covers from about 9 p.m. on the 12th till midnight. We'll continue to look for what they've requested, and as soon as if it's located, we will turn it over. 303 has been completed, 304 has been completed, and 305. The next series, 306, 307, 308, 309 are all part of the 2-week process. As detailed in our response, we've been told by the FBI that it's going through their process, and we're hoping to hear something back about whether or not these are approved and when they're going to be provided in early June. 313 is done, 314 is done, 315 is part of, again, the 2-week process, as well as 316. Again, we should know more early June. Back to videos, 317. The first thing they asked for is this US Bank video. That's been provided. Ampersand, to our knowledge, it doesn't exist. Again, we'll do our due diligence to make sure. If it's located, we'll provide it. One World Cafe does not exist. And 9 to 5 is actually US Bank, and that's been provided. Red Star Coffee, we have, and 319, 320, 321 are all ones that are still outstanding. We'll continue to try to locate those. If they exist, we'll turn them over. 324, 325, 326 have all been complied with. 334 does not exist, and there will be a supplemental report to that effect. 335, 336, 337, 338, 339, 340 have all been complied with, and that gets us to the end of the 5th for this hearing.
Thank you. Any response?
Your Honor, just
That's all. Oh my God, that was long and boring. Hopefully, this is almost over, I swear. So hopefully she doesn't say a whole lot here because we only have a few minutes left.
really briefly, I want to talk about item 226, the Hemisphere program. Ms. Jennings asked me if we meant the timing advance program. That's one and the same. I just heard her say that those records don't exist. I just need to be clear, if they don't exist, then I need to know that. If they do exist and they were used, I need to have them. She mentioned that item 250, 250, that's the balance training records that we had. That we don't have that. That's balance training records related to the use of the Gladiator machine. We don't have those. 251 is partially complied with. That's the certificate on whether the Gladiator machine was working appropriately. We need the follow-up the next time that machine was put back for testing. Both machines, there were 2. 263 and 264, Balance and Kennedy's past training records. I'm happy to hear that I'm going to get those. With regard to the videos on exhibit RR that the court has under number 21. This is where the business said they already had given over their videos, and Ampersand and One World Cafe are both listed on that as well. So they were given to somebody to go to Moscow Police Department at some point in time. And that's it for clarifications for me. Thank you.
Great, excellent. Anything else? No. Okay, great. All right, a lot of work there for all of you, maybe a lot, but finally take a break, and we're supposed to start the second chapter here when we start at 2:00. That's okay. All right. So we'll reset.
I don't, what 2:00 thing? But whatever the 2:00 thing was not aired because this is the end. So I don't know what the 2:00 thing was, but we just endured a very long and boring list of discovery that the defense still has not received from the prosecution. Some of it they're saying, yeah, we'll turn it over. But if they actually do, that's something totally different than saying that they're going to do it, because they have a tendency to not turn it over, even after saying, yeah, we'll turn it over. So hopefully the defense starts to get some of these things and they can start digging into their investigation. Because really, defense attorneys investigate more so than law enforcement sometimes, because they have to recreate and try to redo what the cops are saying. And sometimes if that's not the right angle, then they gotta go and investigate all these different other angles. And so cops do, or I'm sorry, defense attorneys do a lot of investigating in these cases, even when law enforcement has ended their investigation into it. And it's really important that they do that, because they can see where the issues are in our justice system and hopefully try to correct those errors. I mean, there's so many things against a defendant and their attorney coming into a courtroom anyways. Most people think, well, if you're in custody, you're probably guilty. So they already have that prejudice in mind. And they have this idea that prosecutors and cops and judges are all on the up and up, and we should just trust the system. Well, that's the problem. We all have just been trusting the system for way too long, and we haven't been paying attention to what's happening. Now that we're paying attention, we're seeing that people are being put away for reasons that they may not have anything to do with. And law enforcement might just be crooked. And so are prosecutors and so are judges in a lot of these cases that we're looking at where there's some misconduct going on. It's usually coming from that end of things, not the defense, coming from the defense. And the world thinks defense attorneys are like these slime balls, and really they're not. They're trying to defend our rights, our civil constitutional rights. And they're the only ones in this country that are really doing that. So please don't think too badly of defense attorneys, especially because you never know when you might need one. And on that note, I'm going to let you guys go. Thank you so much for watching. I really appreciate you guys for being here. Hit that like button on your way out. Thank you so much again, and have a good one. Bye, guys. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.